I would like to mention one anticipatory bill application, Lordship.
Yes,
One anticipatory bill application unlisted, Lordship, for today.
today.
For today. This regarding 0 PS under 1380 of IBC, Lordship. Your Lordship, item number 4 also. This matter may be adjourned for today, Lordship. Criminal petition 154 of 23, Lordship.
You want to adjournment?
Yes, for today.
Item number 4.
Yes, Lordship.
You are Mr.
B. Taba.
Other side, criminal petition.
Yes.
Bring for adjournment
Much obliged.
after 2 weeks.
Madam, madam.
Yes,
I beg to mention item number 9, madam.
9.
9. With consent of other side, my lord, may pray this be listed after 3 weeks, my lord, in admission column, my lord. This item, my lord.
With the consent of other side.
Yes.
Here for
Admission in the admission column, my lord. After 3 weeks, my lord.
after 3 weeks.
And in 3, my lord, may be continued.
Interim is there. Term is extended.
Obviously.
May I please, my lord?
Yes.
My lord, I beg to mention item number 13, my lord.
1 3.
Yes, my lord.
What do you want? Adjournment.
Yes, my lord.
Yes,
Leading
Mr.
M. Doji, my lord.
After 2 weeks.
No, my lord, matter may be kindly taken up on next
After?
Monday, my lord. Coming Monday, my lord. Next Monday, my lord.
Next Monday.
Yes, my lord.
Next Monday, what will be the date? Next Monday, today is
12, my lord. Obliged.
May I order?
yes.
I beg to mention item number 17.
17.
17.
Yes.
Your Lordship, this matter may be adjourned for today and fixed after 3 weeks.
Why? Your father, appellant or
Bless Pandan.
respondent?
Yes, sir.
Will you please come this side.
Sorry.
Who is the appellant? You are appearing for appellant. Yes. You are also not ready to argue the matter.
Yes, she's taking time, Your Lordship.
Yes.
Your Lordship,
2019 matter.
Your Lordship, the leading council is out of town.
Yes.
The leading council is out of the town.
After 1 week?
No, Your Lordship, after 2 weeks.
After 2 weeks. maybe. You are miss?
M. Likha on behalf of Ojing Pada.
OC?
Pada.
Okay, using father. And you are miss, you comment.
Yes, Your Lordship.
May I, Your Lordship? Your Lordship, I beg to mention item number 10 and 11. It's a connected matter.
10 and 11.
Yes. Your Lordship, I pray the matter may be adjourned for 3 weeks because we have yet to file counter affidavit and we have taken consent from the other parties.
You're for the petitioner.
Mm,
You're for the petitioner.
For number 10, I'm the respondent, and for number 11, I'm for the petitioner. Yes.
And you're for the
Respondent.
respondents. After 2 weeks, you
After-
want to file an additional affidavit.
Yes.
You miss?
Sorry.
You miss?
El Thosum.
Counsel for the appeal. In 10, you are for the petitioner.
Yes. No, in 10, I'm the respondent.
Ah,
11
Okay,
is.
10 for the respondent, and in 11 is for the petitioner. And praise for 2 weeks time,
3 weeks.
3 weeks.
Yeah.
Trying to file an additional affidavit. Allowed?
A counter affidavit, Your Lordship.
Yes?
Counter affidavit.
A counter affidavit, okay. Counter affidavit. In reply to objection,
Yes.
counter affidavit, which is in reply to objection filed by the petitioner. After 3 weeks.
Much obliged.
The other side has made the objection.
Yes, please.
Yes,
My lord, I beg to mention item number 3.
three.
On item number 3, on
Three.
behalf of N. Ratan, kindly grant 3 weeks time to reply the counter affidavit. Second consent from other side also.
You're Mr.
P. Harming.
On behalf of the other side.
I have taken consent from other side. My lord, I beg to mention one more item. Item number 12.
Item number?
12. 1, 2. On behalf of respondent, Gumto Kapo. Maternal list after 3 weeks. Oh, sorry. Sorry, my lord. Maternal picks on 7th of this February.
7-2.
7 single 7 February.
7-2. Yes, 7-2.
No. Yes.
That is item number 12.
Yes.
Item number 12 on 7-2.
Much of.
May I please, your lordship? Lordship, this is a 439 application. Case registered under section 419, 420 of IPC and read with section 66D of Information Technology Act. He was arrested on 15/12/2023. As of today, he's 53 days behind the bar, lordship. Lordship, FI is in case number 10. May I read it out, lordship? With subject cited above, I am lodging an
Page
FI.
number?
Case number 10, lordship.
10.
10.
Yes.
With subject cited above, I am lodging an FIR against one Sri Manoranjan Gogoi, data operator contingency, staff of DEO ERO office for misusing the Aeronet apps for ERO, NIAPIN and illegally included electors in the E-rule of 1913 blank law and 1939 Kumair polling station, due to which abnormal increase of electors were seen in draft electoral rule of 19th and NIAPIN ST Assembly Constitution without the knowledge of ERO. The official might have involved in doing such illegal activities with a malafide intention. Because if here in this case from the FI itself is transpired that the entire case is covered by the IT Act, lordship. Section 419 and 420 IPC have wrongly been invoked in this case, lordship. And case is registered under section 66D of Information Technology Act. 66D says, lordship.
IT Act.
IT Act, lordship. B, it says that punishment for sitting by personation by using computer resources. Whoever by means of for any communication device or computer resources sits by personating shall punish with imprisonment of either description for a term which may extend to 3 years and shall also be liable to be fined, which may extend to 1 lakh rupees, lordship. Section 77B says offences with 3-year punishment. Section 77B says offences with 3 years imprisonment to be bailable. Notwithstanding anything contained in the Code of Criminal Procedure, the offence punishable with imprisonment for 3 years and above shall be cognizable, and the offence punishable with imprisonment of 3 years shall be bailable. So here in this case, lordship, section 66D is a bailable one. Section 81 of the Information Technology Act, it says that the provisions of this act shall have effect, notwithstanding anything inconsistent herewith containing any other law for the time being in force. So, lordship, prima facie, this case is covered by Information Technology Act. Section 419 and 420 have been wrongly invoked in this case. As the case pertains to Information Technology Act, lordship, and section 66D is a bailable one, and that apart, section 81 says that it is an overriding effect. So, case is covered under section 66D. Even though, lordship, he has been arrested and he is put behind the bar for last 53 days, lordship. So further custodial detention may not be required here in this case, lordship. And so my humble submission is that he may be enlarged on bail, lordship, at any condition, lordship. Just 53 days has been.
In fact, your lordship, the FIR on was just a complaint, your lordship. Subsequent to that, your lordship will come to page number 14.
Page number
For-
14.
Yes. Subsequent to such information, your lordship, an inquiry was, preliminary inquiries was done.
Page number 14, yes?
Yes. This inquiry report has been registered as an FIR, your lordship. Your lordship will see at paragraph 4, where the involvement of accused is being
Okay,
shown.
Paragraph 4.
But, this is a regular way, your lordship. At this stage, your lordship, only CD may be called for. Otherwise, even on last Thursday, your lordship, one of the accused, what actually has happened in this case was that in a constituency, namely Nyapin, your lordship, he was a contingency worker, your lordship, in the office where he was given the password and ID for login of the electoral. Since the election is coming, your lordship, yes, he was offered an total amount of 24 lakhs, your lordship, and with connivance with other accusers, your lordship, he has enrolled 7 other persons number whose name and IDs are not known, your lordship. Such was the.
Lordship, I have
Yes.
another submission, Lordship, in page number 18, Lordship. I have enclosing here is a written statement by
Yes,
filing by this present petitioner before the officer in charge of Nyapin police station, and a copy is also been sent to CEO office Nirbasan Bhavan and DO office of Koloriang, Kurungkumi district, Lordship, page number 18, Lordship. He has kept
18.
page 18, Lordship, yes. In this, Lordship, he stated, with the subject cited above, I see Mononanjan Gogoi, son of Sri Honidhar Gogoi, resident of so-and-so, do hereby affirm that I am working as a data entry operator, DO office, Koloriang district, Kurungkume, Arunachal Pradesh, and it has come to my notice that an FIR has been lodged against me regarding abnormal increase of voters in the draft year of 19 Nyapin Assembly constituency without the knowledge of ERO. It is to be mentioned that inclusion of voters, electors is done through public apps of Aeronet. That is, every citizen can apply for the enrollment in the electoral roll through the app. My service or duty as a data entry operator is to print out the applying electors set list and hand over the ERO. Therefore, to accept or reject new electors is solely done by the ERO. Therefore, there is no any active role in my end in inducing new electors. Lordship, here the case is that there is an increase of names of electors, Lordship. And he being a data entry operator, he cannot increase or decrease because it is in public.
Yes, only CDs to be called for, yes.
Lordship, as of now, 53 days. he has
Because
been there.
otherwise the CD says otherwise, your lordship.
CRPC in connection with NIPIN, NYAPIN. Base case number 0123 under section 49420 of IPC. Read with section 66D of IT Act. Call for the case diary. Yes, date.
Short date may be given, Lordship, already 53 days.
You tell me your date, you have to ask question.
The next date, next, during this week, last, three. How many days? it will take, I don't know.
In that case, fix the matter on 14th of February.
14.
Yes, your lordship.
14 days. No, it will be over and
That's why
mandatory
I'm
period.
asking you to at least say a date, you are
419,
coming from outside, na?
419 mandatory
What?
period is 90 days.
Deeply aware.
Deeply applied.
What I am saying under section 438 of the CRPC.
Four thirty,
Yes, 38, in connection with the Itanagar PS case number 13 of 24. My lord, fact of the case is that I was going towards Itanagar on 27th at around 11 p.m. Near Bank Tinali area. And then from behind, I was driving slowly. From behind, one Scorpio car, he hit me. Then I stopped my car and
yes,
I stopped my car and I requested to the driver. One driver was driving in front seat. One lady was also there. Then you are not they were not getting down. Then they were just going towards Itanagar. And then I followed and I entered. Then I came in Itanagar. That driver and lady, they went inside their own house. Then I requested from the outside, so let us stop. Why you hit my car? Then they fired lots of gun from the inside. Then I went back, and on 28th, I sent my people, as far the tribal people, I used to, there may be some problems. We discussed outside the court also. So I sent my people to discuss why they hit my car. Then they agreed on 28th to discuss that. Again, on 29th, on FIR is page number 13. It says that on 28, police received on 29 and accordingly registered the case without, I didn't know anything. Then one notice, my lord, one notice is also issued. Notice is on page number 9.
452, no? 452 is the attempt to house trespass
House-
for preparation of art.
452. For the house trespass after preparation for hard, assault or wrongful restraint. So notice is also issued.
Notice
I-
was
Notice in page number 9.
page 9.
Yes, police. Yes. My lord, I am ready to attend, to give my statement to the police. So I may be allowed to.
You have appeared, no?
No, I've not appeared. So if I appear means this is not valuable, again, I'll be arrested. So I'm ready to appear today also. So
Yes.
I'm.
Yes.
Lordship, though the allegation is serious, Lordship, but if he is ready to cooperate, Lordship, then he may be allowed to, Lordship, to give a statement, Lordship, before the IO, Lordship.
No, this is 452. 452 is a house trespass
Yes, Lordship.
with preparation to assault.
Lordship is there, Lordship, but there, Lordship, this
See the
paragraph 5,
FIR.
Lordship.
FIR, there is nothing. What is FIR 13? Along with my brother was coming.
Lordship, as there, Lordship, paragraph 5, Lordship, it is, they have stated that, Lordship, the informant has tried to kill him, Lordship, and behind to fire the several round of gunshot and miss him in a petitioner, Lordship, and to escape. And just to hearing the false statement informant, they had been registered against him. Now they state he goes to police station for filing an FIR or to give his statement, they are likely for arresting him. Here's the apprehension, Lordship. And if the Lordship, because the allegation serious, Lordship, and Lordship, if Lordship,
Okay.
yes,
So,
Lordship. The CD may be called for less, Lordship. To Lordship, with
So
their
what
his
is
statement.
It appears means Itanagar.
It is not.
438 in connection with Ita PS case number 1324 under section 450 to 506 IPC. Or for the case diary. Yes,
I may be allowed only because I have to give my statement. Actually, I should have given my counter FIR, but because of this reason, so I didn't lodge any FIR. Actually, I should have. But on 28, I have sent my people to discuss about the matter. So I may be allowed on interim. I am ready to cover anything.
after appraisal of CD, what about interim?
Lordship, it may be Lordship, because he's ready to cooperate with the investigation, Lordship. So he may be appear before the IO for the statement.
Then will. Heard Mr. Swayan Learned Counsel for the petitioner and Mr. Okay, appearing for additional epic. This is petition 438 in connection with ETA case number 13/24 under section 452.06 IPC. It is submitted by Learned Counsel for the petition of that. You have trespassed into the campus. of
Actually,
the-
I didn't into the house. I just pour from the outside the building.
Only entered into the house of the informant, not with the intention to assault or hurt any member of the inmates of the house. He received a notice from the Ayub under section 41A to appear before the investigating officer on 2/2 as the offense is non-bailable 452. So his apprehension that he will be arrested, he has appeared before the Ayub. He is willing to cooperate with the investigation. Interim is granted to the petitioner, and an addition of the also was made submission that he may be allowed to appear before the Ayub for recording his statement, considering the prayer of the parties, prayer of the Ayub, prayer of the petitioner is allowed. Within 10 days here, within 3 days, we have to.
Attend today also.
Within 3 days of his paper before the Ayub with and cooperate in the investigation and so on, so. Or for the case study is date
Lordship, then, on 9, Lordship, 9 February.
9.
Lordship. Apply.
Respondent de la calle. Petitioner side is absent, Your Lord.
Petitioner not appeared.
Yes, Your Lord. This case, they have challenged the complaint case filed by the respondent number 2.
The complaint is.
Yes, Your Lordship, the same has been filed by the forest officer, Your Lordship. The respondent number 2 against the petitioner, Your Lordship.
None appears for the petitioner. However, Learned. Additional PP.
Yes, Your Lordship. I'm
You're
41.
for the
Respondent number 2.
respondent two. Respondent two is also present. And list the matter after 1 week. Huh? This interim is there, no? Has not appeared, interim will not be considered. Right now.
Okay, Your Lordship. Your Lordship, in this case, the case diary was called for, Your Lordship, but unfortunately, today also, we have not received the case diary, Your Lordship. Let this matter be listed again on 9th, Your Lordship. On 9th,
Ninth?
yes, Your Lordship.
CD is not available.
Yes, Your
You're
Lordship.
on interim? No.
No, Your Lordship. This is the fourth CD calling, Your Lordship.
4th time.
Yes, Your Lordship.
Yes. There is an interim perhaps, Your Lordship.
Here.
Yes, Your Lordship, interim order is there, which was passed on 13/12/2023.
You are on interim.
Yes, Your Lordship.
So let this matter be listed again on 9th, Your Lordship.
9 2.
Yes, your
Yes,
lordship.
your lordship.
On 9th, we'll produce the case
He
diary.
is not available. Interim is extended up to 9 2.
Deeply obliged, your lordship.
Oblige, your lordship.
Also, this is a pre-arrest bail. In connection with Namsa PS case. Lordship, here the CD was called by this honorable court.
Your lordship,
See,
CD receive and your lordship, now this case is not maintainable because why, your lordship? The accused has been declared proclaimed offender, your lordship. And it has been held by the in of judgment by the Honorable Supreme Court. The anticipatory bail, the proclaimed offender is not entitled for anticipatory bail, your lordship. Your lordship may kindly come to the 3rd page, your lordship.
3rd page.
Yes, your lordship. Second para, in the light.
In the
Light of the above fact and circumstances, I deem it fit to allow the prayer of IO. Hence, accused Saurabh Kumar is declared as proclaimed offender, who is evading his arrest and remain absconding in connection with so and so case number. In the meantime, issue an standing NBWA against the proclaimed offender Saurabh Kumar. Let the copy of this order be furnished to the OCPS so and so. The order copy furnished so and so. The concerned OCPS, as mentioned above, on the execution of the standing NBWA shall produce the proclaimed offender before the learned court of JMFC, your lordship. Your lordship, in support of my submission, your lordship, I would like to rely the judgment of the Honorable Supreme Court, where it has been held that the proclaimed offender is not entitled for anticipatory bail. Your lordship may directly come to para 12, your lordship.
Page?
Page, your lordship,
Para.
para 12, your lordship.
Para.
This case was reported in 2014, volume 1, SCC criminal 768. Para 12, your lordship.
Para 2.
Yes, may I read, your lordship?
Yes.
Recently in Levis versus State NCT of Delhi, reported in so and so, this court, of which both of us were parties, considered the scope of granting relief under section 438 vis-a-vis to a person who was declared as absconder or proclaimed offender in term of section 82 of the code. In para 12, this court held as under. From this material and information, it is clear that the present appellant, who was not available for interrogation and investigation and was declared as absconder. Normally, when the accused is absconding and declared as a proclaimed offender, there is no question of granting anticipatory bail. We reiterate that when a person against whom a warrant has been issued and is absconding or concealing himself in order to avoid execution of warrant and declared as a proclaimed offender in terms of section 82 of the code, he is not entitled to the relief of anticipatory bail. It is clear from the above decision that if anyone is declared as a absconder or proclaimed offender in terms of section 82 of the code, he is not entitled to the relief of anticipatory bail. In the case on hand, a perusal of material, that is confessional statement of so and so, revealed that the respondent administered poisonous substance to the deceased. Further, the statement of the witness that were recorded and the report of the Department of Forensic Medicine and Toxicology, Government Medical College and Hospital, Nagpur, dated so and so, have confirmed the existence of poison in milk robbery. Further, it is brought to our notice that warrant were issued on so and so for the arrest of the respondent herein. Since they were not available, traceable, a proclamation under section 82 of the code was issued on so and so. The document Annexure P13 produced by the state clearly shows that the CGM so and so MP issued a proclamation requiring the appearance of both the respondent accused under section 82 of the code to answer the complaint on so and so. All this material will neither adverted to nor considered by the High Court while granting anticipatory bail. And the High Court, without indicating any reason except stating fact and circumstance of the case, granted an order of anticipatory bail to the both accused. It is relevant to point it out that the both accused are facing prosecution for offense punishable under section 302 so and so read with 34 of the IPC. In such serious offense, particularly the respondent accused being proclaimed offender, we are unable to sustain the impugn order of granting anticipatory bail. The High Court failed to appreciate that it is settled position of law where the accused has been declared as absconder and has not cooperated with the investigation, he should not be granted anticipatory bail. So therefore, it's a clear case, your lordship, and order clearly reflect that he has been proclaimed. So therefore, anticipatory bail at this stage is not maintainable.
Yes.
Lordship, with that I agree to it, but Lordship have to see, Lordship, when I had filed this anticipatory bail, at that point of time, Lordship, whether like I had concealed or not. So I just want to know when does
When did you
proclaim
file the
offender,
petition?
I had filed it on 10/1 of 2024.
10?
10/1 of 2024. 10 January 2024. At that point of time, whether I was declared proclaimed offender or not, Lordship.
Yes. 12-month.
If that is then,
Your Lordship,
Also they received the report. You can surrender. What's the problem?
even if your Lordship, it is not principle of 167 will be applied in this kind of cases. From that time till that he is evading arrest. For that, your Lordship, he has been declared proclaimed.
So cities also received.
Yes, your Lordship, CD has also received.
So we cannot consider.
that, Your Lordship, I have been declared proclaimed offender, that is different. But Lordship, that's what I'm saying. When the proclamation was declared, after my filing or before my filing, Lordship?
Not Mr. Plan of counsel for the petition. CD is received in connection with the NAMSAI PS case number 40/23 under section 420 IPC. He's originally hailing from other state, no, Bihar.
Yes, Lordship. Here, Lordship, the main accused person who is the alleged to be a kingpin has been arrested and released by the Lanet court below.
Subsequently, then you have left the place and not appearing before the court. It is submitted by Lanet counsel for the petitioner back. What are the grounds you have stated in their petition?
Lordship, in the FIR, nowhere my name has
His
been.
name is not in the FIR.
Not in the FIR, Lordship, and the main kingpin who has been alleged, was arrested, he was behind the judicial custody for 33 days and he has been released by the Lanet court below. And Lordship, in whose account the statement of bank manager has been taken and in whose name the bank account was opened, his statement also has been recorded by the investigation officer. So as such, Lordship,
Submitted by the Lanet counsel for the petitioner that the name of the present petitioner is not mentioned in the FIR. And the main kingpin of the case, he was earlier arrested and after completion of mandatory period. He was
not
released.
mandatory, Lordship, 33 days he was.
33 days.
33 days.
After 33 days, he was released on bail by the trial court.
Trial court, Lanet JMFC.
Few of them, the pre-arrest were they considered to the petitioner. On the other hand, Lanet additional duty has submits the petitioner was declared absconded by the court of
Your Lordship, Court of
judicial magistrate.
Namsai.
yes, your Lordship.
Judicial magistrate.
Judicial magistrate first class.
NAMSAI. And and he was declared hostile, declared absconded on 12/1/24. It is a settled position of law that a person who is declared hostile is not entitled for pre-arrest bail. In support of a submission, none of the additional duty has realized on case law of Honorable Supreme Court 2014, volume 3.
Your Lordship, 2014, volume 2, SCC, equivalent citation 171.
171.
Yes, your Lordship.
171. State of Madhya Pradesh, no?
Yes, your
State
Lordship.
of Madhya Pradesh versus Pradeep Sharma. In the same case, the Honorable Supreme Court has held as follows. Para 12, no? Para 12. Para 12 and 13 also, no?
Yes, your Lordship. 12, 13. Yes, Your Lordship. Deeply obliged, Your Lordship. Please, Lordship.
Lordship, this is an anticipatory bail application. Lordship, on the last date, that is on 23/1/2024, this honorable court has pleased to grant interim,
Interim, you are
yes,
on interim.
interim to the accused applicant. Lordship, thereafter, with a direction to surrender before the IO of the case within 7 days.
Yes,
And also instruction was given to the applicant to cooperate with the investigating authority. Lordship, in compliance to the said order, the accused applicant has appeared before the IO. He has given his 161 statement, and accordingly, the accused was arrested and later on released on bail with the terms and conditions. He was released on bail on 29/1/2024, and he has also deposited rupees 20,000 as a surety.
the CD is received? Any statement was recorded?
Yes, Lordship. A statement of the accused has been recorded, Lordship. Statement accused.
Statement was recorded, no?
Lordship.
So matter be,
Yes.
absolute.
Lordship,
problem?
there's a certain Lordship, objection is there, Lordship. During the course of investigation, it is found that Lordship, to ascertain Lordship whether the elite to number of checks already been is missing, Lordship, from this alleged accused, Lordship, which is stolen by him as per during the investigation revealed that, Lordship, and it is also admitted that the alleged accused, the Lordship, which is the applicant, Lordship, have 3 blank check with him, Lordship. Out of 7 is still, Lordship, missing, Lordship.
Not yet recovered.
No, not Lordship. So Lordship, to ascertain
Stolen articles.
Lordship, the check, Lordship. This
Check.
is checks, Lordship. As per the allegation, Lordship, he has been, Lordship, this is not first time, Lordship. The earlier also he has done the same thing,
As
Lordship.
per report of the IO.
Lordship. Lordship, may I see, Lordship?
So you are not cooperating with
No.
the investigation.
I am cooperating. I appeared more than 4-5 times before the IO.
This is not something to appear before that is not enough. You're also
No.
doing the order of the IO also to hand over certain checks.
Lordship, whatever documents I'm having, I have already given, and they have given me on, they have already made seizure of those articles which I have.
Caesar, any Caesar is there?
Yes, Lordship, seizure is there. The agreement between the accused applicant and the complainant, which was executed, it has already given to the IO of the case, Lordship.
Lordship, my humble prayer, Lordship, let them, Lordship, this bail loss should not be absolute today, Lordship, because some more time may be given to the accused to appear before the IO, because investigation has not been
To
completed,
hand over
Lordship.
those documents.
Lordship, yes, Lordship, whatever it is with him,
One
Lordship.
Caesar memo is there. Let's see. One being published by him. Okay. Sure.
complainant, Lordship.
Lordship. Lordship, one more Lordship, person is involved here, Lordship, who has withdrawn Lordship, which is Harmonda Fernanda Lordship, which withdrawn 7.35 lakhs because, and also notice been issued against him also, Lordship, 41A Lordship. So there's a conspiracy, Lordship, also been shown, Lordship, in this case, Lordship. So today, Lordship, it's not been absolute, Lordship, some more time maybe
Some more
given, Lordship.
time is to ascertain the recovery many bank checks. Check number is given, except withdrawn check, so and so, which have been found missing from the custody of the alleged accused. So you have to ponder over this check that is missing.
May I please, Lordship?
Check number 759108, no?
Lordship.
There is, Lordship, the complainant has not given this check. Lordship, may I brief the fact of the case? Lordship, here in this case, it's not the case where the accused person has
Yes,
stolen the
where
check.
there's total 7 numbers of blank check. The blank check that is also not recovered have been also missing from the custody of the alleged accused or stolen by him. Anyway, this you can appear again. Heard Mr. So and so learned counsel for the petitioner and learned addition of the Ms. Sadi. CD is received, Perutta Sen. The learned counsel for the petitioner submits that as per order of this court, the petitioner has appeared before the IM for recording his statement, and he is also cooperative with the investigation, so his bill rate may be, and there is no allegation that he has misused his liberty, so his bill rate may be made, interim may be made absolute. The other hand, learned additional PP submits that some more time is given to the petitioner to cooperate with the investigation by submitting some checks. As per the report of the IO, that he has not handed over some checks which is still missing. So today the interim granted to the petitioner, not made absolute, hard done also for the parties. It appears from the this diary that the withdrawn check bearing number 759108 is missing from the custody of the alleged accused petitioner. Apart from that, 7 numbers of blank checks which are also missing from his custody, stated by the custody of the accused or stolen by him.
It is not stolen, Lordship. Actually, Lordship, the accused person and the complainant, they were business partners. So the informant, the complainant has given this check to the accused person.
It's a question of some still, it's a blank checks also.
Those,
So you have to, so let's see. So petitioner is directed to hand over such checks to the investigating officer within 1 week time.
Lordship,
Give
those
it-
checks are not
10.
with, those checks are not with me, Lordship. It is just a mere allegation in the FIR.
2 weeks, Lordship, after
2 weeks. 2 weeks time,
They'll return.
along with the case diary. Case diary be returned back.
And
With the
updated
direct-
case diary maybe.
Updated case.
Updated case diary, resubmit the same after
It-
2 weeks.
Interim may be continued. Lordship.
Interim is extended.
Okay.
Deep oblige.
Minutes.
Your Lordship,
Yes.
this is a convention delay petition,
Section 5,
section 5.
the other side not appeared. How
Yes.
many days of delay?
38 days. Your Lordship. And service of notice.
Yeah, for the insurance.
Yes, Your Lordship. Service of notice for TN 3 to 5 are waiting, and only respondent number 1 and 2 has been served.
1 and 2, anybody appeared? No.
No. Nobody file vocal.
So await service regarding respondent 3.
Respondent number 3 to 5
1 and 2 already
only
served.
served, Lordship.
3, 4 and 5
Is waiting,
not served.
not served.
What learner counsel for the petitioner?
SP.
Notice regarding respondent 1 has been properly served to the respondent 1 and 2, but none has appeared. Await service report regarding respondent 3, 4 and 5. List the matter after 2 weeks. 2 weeks?
4 weeks. Okay. 4 weeks.
Hello. May please, my lord. My lord, matter may be pass over for a while. Leading counsel is in another problem.
My lord,
Yes.
if I may, my lord, this may be kindly pass over. The counsel for the respondent number 2 is not here yet. Your Lordship.
Possible for the day,
Oh, no, for the time being, no ship.
for the time being.
For the time being, no ship. Much obliged.
Thank you.
May it please your Lordship. Well, this matter will take some time. This is a hearing matter, it will take some time. I hope the other sides. Where is the respondent motion? Wait for them. This was it for them?
Yes, yes.
My lord, I have prepared a small list of dates, my lord, because the facts.
Yes.
Hello, excuse me. Hello, this will help the court to understand the sequence of the event in a chronology, my lord. Now, my lord, in short, my lord, what had happened in this case, my lord, and there, my lord, I'll just give a brief background of the case. A loan of rupees 5 lakh was taken by my client, that is the petitioner, from the private respondent, my lord. My lord, the money could not be repaid, and thereafter a check was issued, my lord, in repayment of the money. Now, what happened, my lord, in the check, my lord? While signing the check, my lord, on the bottom, the petitioner has written 2018, but on the top of the check, it was written 2016. That by inadvertence, my lord, the check was accepted by them.
Accepted by the other side. That's right.
They have accepted. They have the check in question. The original check is in their possession, man. The check was accepted by them. Thereafter, my lord, they were not settling with the said amount of 7 lakhs because there was an interest component in the loan. We paid 7 lakh, taken 5 lakh, but my lord, thereafter they sent me a legal notice saying that you pay the money. in response, my lord, I sent a legal notice saying that I have already given a check. Still, if you want the money within 15 days, you can come and collect the check value from me. They don't come. They move to a local authority, my lord, which is called as Kebang or Mel, the local village authority, my lord. Now, my lord, in the village authority, I'll come to that, my lord, because, my lord, the village authority as on date does not have any power to adjudicate civil or criminal dispute, because now the judiciary and the executive has been separated in the state of Arunachal Pradesh. Now, the extra assistant commissioner, he assumed power, my lord, of his own and started entertaining this matter. And eventually the village authority saddened me with an amount of 20 lakhs. That is 405 times of the check amount.
Check.
Now, my lord, thereafter, my lord, what happened? The extra assistant commissioner, he, my lord, from source best known to him, has assumed the role of an executing court. And he started issuing notice for execution of the village authority's order, my lord. My lord, I'll come to all this, my lord, it is there. I'm just giving an idea, my lord, what has happened. Now, my lord, when I received, there was a show cause notice which was issued to me after the order of the village authority that why I am not paying it, I should pay it. Now, my lord, in response to that show cause notice, my lord, I furnished a reply and a photocopy of the check which was with me. The original copy is in the possession of the private respondent. In response to that reply. Now, my lord, after 2 years, they say that in that photocopy of the check, there is a manipulation with regard to the date 18, because initially check is top 16, below 18. Now both became 18. Now they filed after 2 years, when it was in the custody of the court, they filed a criminal complaint against me, my lord. Now, my lord, the FIR was registered, they filed an FIR. The FIR was registered under 420, 467, 471 on all these sections, my lord, cheating, forgery, using genuine document, a false document as a genuine document, all these sections. Then, my lord, the charges eventually was framed under 192 part 2 and 465. The charges were framed under this section. Now, my lord, there is one small parallel fact. My lord, the village, the execution proceeding, as well as the order of the village authority, as well as the entire proceeding which took place before the village authority is put to challenge in a writ petition before this court, and we are, an stay order is operating. Because our contention was that the village authority lacks jurisdiction in view of, I'll take your lordship to that, in view of a division bench order of this court, and in view of in view of the fact that there is a notification which says that the judiciary and the executive has been separated in the state of Arunachal Pradesh since 2014. Now, my lord, I put to challenge in this criminal petition the FIR, the charge sheet, the order of framing charges under section 195 part 2 and 465. Now, my lord, I take your lordship to the facts of this case. My lord will kindly come to page number 34. And my lord will place this list of dates, page 34. This is from where everything started. This is the money loan deed received, whatever. I, so and so, that is the petitioner before your lordship, Assistant Director of Fisheries, State Fisheries Department, Government of Arunachal Pradesh, took a sum of rupees 5 lakhs. My lord is there, my lord?
Yes, 5 lakhs.
5 lakhs. Now, my lord will see the amount of interest. at the rate of 8% per month. That is 80%, more than 80%. It is 96% per year. 8% per month interest from Srimati such and such for a period of 3 months with effect from today, that is 14/9/2015. This is from where everything starts. Now, my lord, I could not pay the loan within time, my lord. Therefore, my lord, they issue a legal notice at page 35. Now, my lord, at page 35, they say that on 40, my lord will kindly take note of the dates. The dates are very important, my lord, because 2015 loan, and now we are in 2024. Now, this legal notice was issued in 2018. It essentially says that I had taken a loan at the rate of 8% per month. I skip the part. The operative part is page 36, the last para. Under the aforesaid fact and circumstance, I am to serve you this notice. You are called upon to pay, return the said loan amount to my client, sum of rupees 5 lakhs with agreed interest thereon within 15 days from the receipt thereof, failing which my client shall initiate a civil criminal case against you for the recovery of the aforesaid amount. So I was put to notice that I need to pay the amount, my lord. Now, my lord, in response to this legal notice, my lord, I issued a check. My lord will find at page number 37. Now, my lord, here my lord will see the problem with this check was this. On the right hand side of this check, your lordship will see 2016. Now, my lord, on the top right hand side, on bottom right hand side, when he signed it, it became 2018. Now, my lord, it is not that, my lord, immediately after signing this check, a case has been filed. It's not that, my lord. It was a mistake, we admit it. Now, in response to this legal notice, we also give a notice to the private respondent at page 38. Now, my lord, here we say him, I'll skip the other because these are all narrations of facts, my lord. My lord will kindly come to page number 39, the last para. My lord will see the language, man.
Yes.
Take notice that further delay in repayment of the money, because we are paying him money, delay in repayment of the money. My lord, before that, I just want to draw your lordship's attention to clause point number 5 of the legal notice on the same page, page 39. 5,
Okay.
same page, page 39.
Page.
That after receipt of your legal notice, my client has personally went to your client's house and discussed to your client for repayment of the money with agreed interest for 3 months and rest of the amount at the rate of standard bank interest for repayment of the money. But your client denied to settle the matter with negative intention of extracting huge sum of money from my client illegally by applying external and internal force. That my client cannot pay more than the agreed interest along with principal amount, and therefore further delay in repayment of the money, my client shall not be held liable because my client had already presented the check aforesaid for settlement of the case. That apart, my client states that your client is making open threatening of dire consequence to my client and defaming everywhere in public domain without any reason by making issues out of no issue. And more shockingly, your client went to Pasighat at the private residence of my client, further demanding the money and threatening. Whereas my client father is not liable to pay the said money in question in any case because your client has refused to accept the check as mentioned above. Now, that it is to note that in case of repeating the house trespass by your client and telephonically disturbing mentally and psychologically again in future without any reasonable ground, my client will make criminal complaint against your client. Now comes the now comes the prayer of the notice, my lord. Take notice that further delay in repayment of the money aforesaid, my client shall not be held liable in any case because my client has already presented rupees 7 lakh in check to your client for settlement of the case. Further, now my lord, I put emphasis here. Further, if your client wishes to accept the check value, that if he wants cash check value of rupees 7 lakh, he may obtain the same within 15 days from today. 15 lakhs from today. Otherwise, under the instruction of my client, I will file a criminal case before criminal court of law against your client without further intimation after receiving of this notice. So, my lord, essentially, if I understand this correctly, this legal notice, it says that I have issued a check because until now I was not told that this 6 and 8, that anomaly was not intimated to me. Therefore, my lord, I say that you can take the check value if you want within 15 days. Now, my lord, this check was accepted by the husband of the respondent number 2.
This check means this one.
This
33, sir.
1618.
1618 is
Page number 88, my lord will kindly come.
88.
88. This is the husband of the,
Okay, receipt.
yes, this is the husband of the petitioner number 2. He receives this check. My lord will see. I received an SBI check bearing number. My lord may tally this number, check number, with that at page number 37. It's the same check. Check amount of rupees such and such only from Sri Tabit Tabak, is an advocate. This, my lord, this gentleman, Tabit Tabak, he was trying to settle the dispute between the parties. Tabit Tabak on 4th November 2018. My lord, while issuing this money received, even that typographical or that clerical error was even overlooked by him. This is the same check at page number 37. That clerical error, that clerical error was even overlooked by the person who has accepted the check, even by the advocate who has accepted from me, and the opposite party number 2's husband who has taken it from the advocate. Everybody skip. These are clerical mistakes, my lord. For personal record, this money received was issued. And this was issued on 4/11/2018. So on 4/11/2018, this check was received by the respondent number 2 through her husband. Now, my lord, this situated thus, my lord, suddenly, my lord, on 15th of October 2018, my lord will kindly come to page number 40. Now, here comes the role of the extra assistant commissioner.
40, yes.
Yes. Here, my lord, it says a mail proceeding has been fixed on 20/10/2018 at 10 AM at Melghor, Naharlagun for settlement of money dispute case in between so-and-so versus so-and-so. Now, my lord, will kindly see the name of this person. Takin Talong. Now, my lord will see, just for a moment, we'll juxtapose it with page number 34. My lord, from whom the loan was taken?
Oh, book. Okay.
No, he has taken it. From
He's
whom it
taken.
has been taken?
Okay, Sarita.
Srimati?
Sarita, I think Sarita.
No, this is from page number 34 from Srimati Otok Tamut Talom.
No.
Yes.
Okay, oh, she is witness. Sarita is witness.
Witness. It is written in the middle, 1, 2, 3, 4, fourth line from bottom, my lord.
Srimati Ottok Tamut.
Yes. So money was taken from her. Some mail proceeding is initiated. We'll see at page number 40. Her husband has initiated. Now, what does it say? A mail proceeding has been fixed on 2010-2018 at 10 a.m. at Melghor, Naharlagun for settlement of money dispute case in between Sri Taking Talom versus Obuk Mije. Therefore, all the contending parties of the said money dispute case are hereby directed to sit in the Melghor, Naharlagun as per date and time fixed above and submit the outcome of the same to the undersigned accordingly. Now, my lord, this mail meeting has been initiated at the instance of the husband of the person from whom I had taken a loan. Now, my lord, here I take a pause, my lord. Now, page 40, this notice which was issued to me by the extra assistant commissioner, it lacks jurisdiction. Because everything starts from this. Where is my copy? Now, my lord, we'll kindly come to page number 67 of this compilation. This is the Assam Frontier Administration of Justice Regulation 1945. My lord, the power of the village authority to decide or entertain civil or criminal disputes flows from this act. My lord, kindly come to regulation 37. Your lordship will find it at page number 77. My lord is there.
Yes, 37.
Yes. The deputy commissioner may try suits of any value. The assistant commissioner may try suits not existing 50,000 in value. 38. The deputy commissioner and assistant commissioner shall in every case in which both parties are indigenous to the union territory of Arunachal Pradesh endeavor to persuade them to submit to arbitration by a panchayat. Then my lord will come to regulation 40. That is the village authority. This is the mail meetings.
Okay.
The village authority shall try suits without limit of value in which both the parties are indigenous to the union territory of Arunachal Pradesh and live within their jurisdiction and which are not submitted to arbitration under the provision of section 38. All other suits which are not submitted to arbitration under the provision of section 39 shall be tried by the deputy commissioner or an assistant commissioner. So, my lord, this act gave power to the village authorities, to the deputy commissioner, to the assistant commissioner to entertain civil or criminal suits. Some has pecuniary jurisdiction and with pecuniary as well as territorial jurisdiction. Now, my lord, this act, now under this act, there is also an appellate authority at regulation 46, the assistant commissioner and the deputy commissioner, any person aggrieved by a decision of a village authority may appeal to assistant commissioner in suit. My lord, may skip that, my lord. That's not the subject matter, my lord. Now, my lord, this act was impliedly repealed by a notification at page number 112 of the petition. My lord will kindly come to page number 112.
One
1112. My lord will see this notification. Consequent upon the appointment of 5 chief judicial 112. No, my lord, this is not the compilation, the petition.
Petition.
Petition. Compilation only this.
112, yes.
My lord is there, my lord?
Yes.
My lord will see, this is the notification dated 6th of Jan 2014.
14.
Consequent upon the appointment of 5 Chief Judicial Magistrate cum Civil Judge Senior Division and 5 Judicial Magistrate cum Civil Judge Junior Division by the state government and subsequent posting of the officers and vesting of power in them by the Honorable High Court, wide notification dated such and such. The Governor of Arunachal Pradesh, in consultation with the Honorable High Court, is pleased to order that the Deputy Commissioner, where the said judicial officers are posted, shall transfer all pending cases, both criminal and civil, to the court of said Chief Judicial Magistrate cum Civil Judge and Judicial Magistrate cum Civil Judge for trial and disposal thereof. Henceforth, all cases, my lord, henceforth, all cases, both criminal and civil, shall be instituted only in the court of Chief Judicial Magistrate cum Civil Judge and Judicial Magistrate cum Civil Judge, Junior Division. So, my lord, from 2014, this notification, all civil or criminal dispute has to be dealt by regular courts. In other words, my lord, that is the civil court or the criminal court, because of the bifurcation of the executive with the judicial. Now, my lord, this issue came up before a division bench of this court, my lord. Because, my lord, even after issuance of this notice, some village councils, some village authorities were taking up civil and criminal disputes, my lord. My lord, that, and thereafter again I'll come back to fact, my lord. Only one judgment I'll indicate, my lord. My lord, will come to that compilation, page number 84. My lord will see, this is this judgment. Sorry, my lord, this is single bench judgment. I'm sorry, my lord, this is single bench judgment. My lord, will be that as it may, my lord, our High Court's coordinate bench judgment, my lord. Para 1, my lord. The government of Arunachal Pradesh took the decision to separate, my lord is there, my lord?
Yes.
The government of Arunachal Pradesh took the decision to separate the judiciary from the executive in an exercise of such power under Article 309 of the Constitution, with consultation with the High Court, has framed rules being Arunachal Pradesh Judicial Service Rules 2006. Judicial officers have been appointed, and consequent to their appointment, the government of Arunachal Pradesh issued a notification dated such and such, directing all the Deputy Commissioner to transfer all the pending cases, both criminal and civil, to the court of Chief Judicial Magistrate cum Civil Judge Senior Division and Judicial Magistrate First Class cum Civil Judge Junior Division. Para 3. It is submitted by Mr. Panging that after the appointment of the judicial officer, the extra assistant commissioner have been dispensed of the power of judicial magistrate, but the extra assistant commissioner, like the case at hand, Itanagar, has continued to proceed with the case between the petitioner and the private respondent in his capacity as executive magistrate, and finally disposed of the same by holding that the dispute plot of land belongs to the private respondent. Now the court's finding. Page 89, para 18 and 20. Para 18 and 20, page 89.
Yes.
It is categorical finding of division bench. Now there is a division bench order as well. It is a categorical finding of the division bench that the administration of justice by the regular constituted courts manned by judicial officer of the cadre will be as per the Civil Court Act, and to the extent the Northeast Frontier Administrative Justice Regulation 1945 conferring judicial power on the executive will cease to operate, the doctrine of implied repeal will apply. Meaning thereby, my lord, that though there has not been any repealing act, but that notification will have the potentiality of repealing the 1945 regulation by invoking the doctrine of implied repeal. So that was repeal. Para 20. Hence, in this case, the assistant commissioner has exercised his jurisdiction as regular civil court in spite of notification issued by the government directing the deputy commissioner, assistant commissioner to transfer all the pending cases, both civil and criminal, to the court of Chief Judicial Magistrate cum Civil Judge Senior Division and Judicial Magistrate cum Civil Judge Junior Division for trial and disposal. The act of the assistant commissioner is contrary to the decision rendered by the Honorable Court in Registrar General case. Therefore, the impugned order dated such and such is liable to be set aside and quashed. Accordingly, it is set aside and quashed. Private respondent will, however, be at liberty to approach regular civil court for redressal of their defense. So, my lord, my purpose of showing this regulation and also this judgment, single judge judgment, which has a reference of a division bench judgment, is to show that this mail proceeding, which was initiated at page number 40, lacks jurisdiction. It is, if I may say, it is non-est. It has no legal existence, page 40. Now, be that as it may, my lord. Now, a mail was conveyed at the instance of the husband of the person from whom I had taken the loan. Now, my lord, I challenge this mail proceeding before the Honorable High Court in a writ proceeding. Page number 42, my lord will kindly come. 42. Now, my lord, this is a representation. Now,
42, you're
no. This is a representation, but my lord, this representation, the body of the representation will say, I filed a writ petition challenging the mail proceeding. My lord, I'll just read it, my lord, the relevant part. It is to inform you that the opposite party have challenged the order dated 24/10/2018, such and such for settlement of money dispute in Mail Kabang between Sri so-and-so versus so-and-so before the Honorable Guwahati High Court, Itanagar, by way of filing a writ petition, which was numbered as 540/2018 on the ground that it is blatant violation of the notification dated 6/1/2014 issued by the government of Arunachal Pradesh. And even assuming but not admitting that the EAC, that is Extra Assistant Commissioner, has taken up the case in terms of FIR, the process adopted by your good office is out of the bounds of any known procedure in terms of FIR or the CPC 19. It is to state that in terms of the AFR, that is Assam Frontier Regularization, under section 18, the Deputy Commissioner or the Assistant Commissioner shall endeavor to refer the dispute to arbitration by allowing each party to nominate equal number of arbitrators who shall then decide the dispute. In the instant case, you have given the list of arbitrators and the witnesses, and moreover, the present area where both the parties reside does not fall within your jurisdiction, which is in violation of section 40 of the AFR. That the matter was taken up on the afternoon being listed as unlisted. The Honorable Court, though did not grant interim to the impugned order dated 24/10/2018, has fixed the matter on 29/11/2018. It is categorically back to state that in spite of due diligence, the order of 1/11/2018 of the High Court could not be procured, which the opposite party will submit as soon as the High Court order is furnished to them. The opposite party, who is in Pasighat discharging his official duty, will be unable to attend the mail proceeding. So pray that till disposal of the writ petition, the matter may be kept in abeyance. We filed a writ petition challenging the order, which your lordship will find at page number 41, that is fixing a date for the mail proceeding. Page number 41, 24/10/2018. A mail proceeding was fixed, refixed in fact on 2/11/2018, challenging this order of 24 and the mail proceeding which challenged it.
41 annexure 6, that is something else.
Yes, this is an order passed by the same Extra Assistant Commissioner,
Commissioner, right.
whereby I am re-notified regarding the date of the mail proceeding. A mail proceeding has been refixed on 2/11/2018 at 10 AM
Yes.
at so-and-so for settlement of money dispute in between Sri such and such and such and such. The please will attend and corporation in such, my lord, the English is also, my lord, will, the please will attend, help and corporation in settlement of the case of this, namely such and such, such and such and such and. Therefore, the contending parties of the said money dispute are hereby directed to sit in the mail Ghor Naharlagun as per date and time refixed above and submit the outcome of the said to the undersigned accordingly. That is the notice refixing the mail proceeding. That was put to challenge. The High Court issued notice. We intimated that, see, the matter is sub judice before the Honorable High Court. Let the High Court take a call because apparently there is a notification, but they went ahead with the mail meeting. I come to that part. They went ahead of the mail meeting, and therefore, my lord, the writ petition became infructuous, and the writ petition had to be eventually withdrawn at page number 46. My lord is there, my lord?
46.
46, it was withdrawn. My lord. My lord, I am just disclosing the facts, my lord, as it exists, my lord. Now, the decision or the, if I may use the word, judgment of the mail authority at page number 47. Page 47.
Page 47.
Hmm.
That is Kebang decision.
Kebang decision, mail stroke Kebang. Now, my lord, one more fact, my lord.
Yes.
Both the complainant, petitioner, and the private respondent, they belong to a particular community from Pasigat area. So, my lord, even the village authorities, if at all they have jurisdiction, which I am convinced that, my lord, and I'll demonstrate it has got no jurisdiction, which your lordship has already seen, then the Kebang has to be held at Pasigat, comprising of the Gaumburas and Gaumburis of their community. Now, here is a Kebang decision in Naharlogun, and admittedly, both of them, they belong to a community which has its roots, my lord, in Pasigat. They are Adi communities, my lord. Now, my lord, this Kebang decision, my lord, may skip this long narration of facts, my lord. My lord, may straight away come to page number 49. The direction, Roman 1. My lord is there?
Yes, sir.
My lord, direction. Since the absent of the opposite party is intentional, my lord, I don't know how they come to these findings, that as per the money received written by himself and promised by the opposite party, the members have no alternative to plead on his behalf. So the total claim amount of the complainant are to be found correct, and accordingly, Obuk Mije is directed to return a sum of rupees. My lord will kindly take note of this sum. 20 lakhs 20,000. 5 lakhs becomes 20 lakh 20,000. My lord, if my sense of mathematics is correct, my lord, it is around 400%.
Yes.
Yes. My lord, you are asking for the calculator, ma'am? Now, my lord, this is the finding of the mail.
Yes.
That 20 lakhs, and it has been signed by the persons who were present. Now, my lord, we'll kindly take note of the date of this, my lord.
211.
211. Now, this date assumes some importance, my lord. My lord, immediately upon this decision, a consequent order is passed by the extra assistant commissioner who is taking personal interest in this matter. My lord, will kindly see at page number 52. My lord, I hope
52. Yes.
page 52. If all development projects would have been taken up with the same promptitude, my lord, this country would have been a wonderful place, my lord. Now, on second, the Kebang takes a decision immediately within minutes. It reaches the table of the extra assistant commissioner at page number 42, and within minutes, he signs an order. Same date, which is why I said, my lord, the date assumes some importance, my lord. We'll see 2/11/2018. Same date.
Yes.
My lord will see the direction on the last two lines, my lord. Rest, he has supported the mail and the regulation. He is saying, my lord, this is a very interesting, my lord. I'll read a part of this, my lord. A mail Kebang decision has been passed ex parte by the village council under the chairmanship of so-and-so of so-and-so place in pursuant to mail order so-and-so, such and such. I'll skip the name and the place and the dates. In between so-and-so and so-and-so under customary law, as per prescribed under the Assam Frontier Administration of Justice Regulation. So admittedly, my lord, this proceeding is in terms of the 1945 regulation. This has to be read in conjunction with the implied repeal as held by the division bench, reiterated by the single bench, and the same is reflected in the order. So admittedly, they cannot now argue that no, this mail has its source in some other, my lord, customary or convention, my lord, because this has its source in the regulation of 1945. It's there. The respondent, despite acknowledging the receipt of the mail notice on 2 occasions, which was served through Sri Tabit Tabak and the OC of the Naharlagun, has intentionally remained absent. Accordingly, the head Gaon Bura and Gaon Buras of respective village has appeared before the mail. My lord, these are all this 20,000 has been the finding of 20,20,000. The last line. In view of the above, you are hereby directed. You here is, my lord, the petitioner before your lordship. You are directed to deposit the aforesaid amount to the undersigned without fail. Not even execution notice. It takes some time even for the executing court to issue notice, my lord. Okay. Now, my lord, then, my lord, the extra assistant commissioner, my lord, at page 8, 53, my lord will see a show cause notice has been issued to me. Page 53. In continuation of this office mail order number such and such dated such and such regarding money dispute case, it has been made known to me that you have not yet complied with the mail order issued by this office even after a lapse of 9 months. Hence, you are so caused as to why necessary action should not be initiated against you. Your reply should such this office, it has to be reached. This office within 10th of July 2019. My lord, I put a question to myself, my lord, from where the extra assistant commissioner is deriving power to issue such show cause notices. Now, my lord, the petitioner gives a detailed reply of the show cause notice at page 54. Now, my lord, here, my lord, while furnishing, my lord, the date of this show cause notice is extremely important for this reply of the show cause notice is extremely important to decide the quashing petition of the criminal proceeding. The date is extremely important. 16th July 2019.
No, 8 July.
No, my lord. 8 July is the reference. 8 July is the show cause. This is the reply.
Show cause notice.
Page 54, my lord. This is my reply.
Reply.
I am on the reply. The reply is on 16 July 2019. My lord, this date has a strong bearing in this case. 16 July 2019. I give a reply to the show cause notice. I say to him that para 2, that sir, I have already paid 7 lakhs in SBI multi-city check such and such to such and such in spite of their asking amount of 6,20,000 through Tabit Tabak long time ago. A copy of the money received and the check is enclosed for your reference, please. That's sir, on seeing that the unusual delay. My lord, here I take all the grounds. Para 5, that sir, both the parties are not native of concerned jurisdiction where mail taken place. I am a permanent resident of Pasigat in East Siang district, Arunachal Pradesh, and I am posted at Pasigat. Any correspondence required my attention should have been posted in my domicile as well as my official address, my lord. So, my lord, here is the issue, my lord. From here, the criminal case starts. Here, I give a photocopy of this check. I enclose a photocopy of this check, my lord has seen, my lord, at para number 2. Para number 2, I say that a photocopy of the check is enclosed. Now, this photocopy of the check is submitted to this extra assistant commissioner on 8th of July 16th of July 2019. Now, my lord, the said manipulation is in that photocopy. I come to that, my lord. My lord, will kindly see page 55, point number 11, my lord.
55.
Page 55 point. That, sir, the village authority have no power conferred to them for imposing and levy at the rate of 405 in 3 months, at the rate of 8% per annum and at the rate of 96% per annum interest rate. My lord, I dispute the amount which has been calculated. By what standard of interest, my lord, not known to at least to the present civilization, my lord, how 405% interest can be levied on a sum. Be that as it may, I furnish my reply. But, my lord, the extra assistant commissioner, page number 56.
Yes.
Now he's threatening me with police. Last para. Therefore, you are served this final reminder to present yourself before the undersigned on 23/7/2019, failing which the OC Naharlagun shall be directed to produce you before the undersigned as per law. Is it not abuse of the power conferred by law, my lord? My lord, now, my lord, page 57. While I was, all the while, my lord, I was posted at Pasighat. I was in consultation with my advocates that what best course should be taken, my lord. I receive another order at page number 57. It says, the last para, the undersigned hereby order the respondent such and such to present himself before the undersigned on 28/2019 at 11 AM to show cause in person as to why mail order passed such and such under the provision of customary law as prescribed under the regulation of our student. My lord, when this mail meeting is fixed, my lord will kindly see the date when it is fixed. It is fixed on 28/2019, my lord. My lord will see, my lord, how I am being harassed at the hands of this extra assistant commissioner. My lord, there is a postal receipt. It was posted in my Pasighat address. The postal receipt is at page number 58. Down below, my lord, when this letter was posted, on the same date. The date when the mail meeting was fixed. The mail meeting was fixed on 28/2019 and it was posted from Naharlagun on 28/2019. He's threatening me with police, sending notice on the day when this is fixed, my lord. Now, my lord, now comes the impugned FIR at page number 59. Now, my lord will see the date. So, my lord, this is, my lord, this is after 6 years from the date of loan and 2 years from the date of furnishing the reply to the show cause notice. The show cause notice reply was filed on 2019, July. Now, why this date is important, my lord? Because in that show cause notice reply, the photocopy which I had in my possession, my lord, I have given a copy of that photocopy to show that 7 lakhs was, that a check of 7 lakh was issued, my lord. That reply, page number.
Yes, I got it.
Pardon?
46.
46. Yes, page 40. No, not 46, my lord.
No, 46.
46 has to be, that is the order of the High Court. The reply show cause notice, reply, that is page 54. Page 54. The date. Because the photocopy of the check, which they are alleging forgery of the photocopy of the check, this photocopy of the check went in the custody of the court on 2019, 16th of July. Therefore, I said, and this FIR has come into existence on 10/6/2021. After 2 years, for 2 years, it was in the custody of the court, if I may at all say so. Now, FIR against Sri Obuk Mije, son of such and such, resident of such and such, for cheating and forgery. Now, my lord, with due respect, I am to state that Sri Obuk Mije, on the pretext of some urgency to engage excavator for earth cutting, such and such, taken a loan of 5 lakhs only on return basis with interest for a period of 3 times. Now, my lord, interestingly, in the FIR, she doesn't mention the rate of interest because she thinks probably that it was exorbitant. 3 months. However, even after 3 months, when he failed to return the amount, I and my husband repeatedly requested him to repay the amount with interest as promised. On 14/6/2018, he sent a check bearing number such and such of SBI Itanagar branch for an amount of rupees such and such only through one Tabit Tabak. Fraudulently, he again written 2 dates in the same check, 8/6/2016 and 8/6/2018. Thus, I and my husband could understand his ill intention to. My lord, I take a pause here. My lord, in case there was a clerical error or I have done it intentionally, for the time being, let me assume that I have done it intentionally. My lord, I wrote a notice, I have given a notice that if you are interested in 7 lakhs, please come within 15 days, take the check value. The dispute would have been settled then and there. But I am not satisfied with 7 lakhs. I am targeting 20.20. Thus, I and my husband could understand his ill intention to cheat me from the very inception of receiving money from me on the pretext of loan, as the said check was issued invalid since the validity period of a check has already expired. I and my husband has been running from pillar to post to get my money back, but Sri Obuk Mije kept on evading and avoiding with fraudulent intent. When me and my husband lodge a complaint before the ESC Naharlagun, has filed show cause notice wherein he again manipulated the said check by putting check date as such and such. My lord, I take a pause here. Not said check. The said check is with them. It is the photocopy of the check. Because I cannot gain anything by manipulating a photocopy. No check, my lord. I do not know whether there is any banking system under the sun where photocopy is honored. And also in the signature column fraudulently, and claimed that the amount of rupees 7 lakhs was already paid as settlement through Sri Tabit Tabak. When we bought the original before the ESC Naharlagun and informed him that the same check is being manipulated, the ESC Naharlagun has directed the OCPS to hold an inquiry. The OCPS, after holding an inquiry, has submitted report to Circle Officer Naharlagun, thereby informing the Circle Officer Naharlagun that the check is being manipulated and Sri Obuk Mije has committed a crime of offense of cheating and forgery. In view of, now my lord, it is important. Now here they admit something. In view of the bar under section 195 CRPC, I could not have directly lodged an FIR to the police. My lord is aware, my lord, the mandate of 195, my lord. So they say that I could not lodge because of the bar under 195. And I have waited the ESC office now, believing that they would lodge an FIR against Obuk Mije as per section 195 CRPC. However, even after waiting for 10 months and when the FIR was not lodged by the ESC Naharlagun, I am compelled to lodge this FIR, and as such, there is a delay of around 10 months. In view of the above, I request you to register a case against Obuk Mije. Now, my lord, a check, a photocopy of a check, which was in the custody of the extra assistant commissioner, after 2 years, the private respondent come and say that there is a manipulation and cognizance has been taken on the basis of this FIR. Now, my lord, page 60. Yes. Now, my lord, the investigation started. They filed charge sheet. During the course of investigation, they record the statement of a very vital person. That person who took the check from me and handed over to the husband of the petitioner. Tabit Tabak, page number 89. My lord will see, because he is an impartial man.
89.
89. We'll see. His statement reveals the actual story, my lord. This is the statement of this man who was in fact trying hard, and my lord, he is also a very, he is also an officer of this court, my lord. He's a reputed man, my lord. His statement, my lord, because he was, in fact, he was trying to settle it between the parties. He took a check, given it to the person who was, though not entitled, but being the husband, we don't make that a issue, my lord. Here, in the statement of Mr. Tabit Tapak, what he says is this, my lord. In 2018, while I was practicing in Guwahati High Court, Naharlagun bench, my maternal uncle, such and such, who is serving as a oath commissioner, Guwahati High Court, called me in his office. Well, I skip these personal details, my lord. I come to para number 3. After a few days, Obuk Mije called me and said that he has taken rupees 5 lakh from Sri such and such at the rate of 8% monthly, and also said that he would pay 7 lakhs as lump sum payment and gave a check of 7 lakhs to me to hand over to such and such. Accordingly, I met Sri such and such and asked to take it from me, but such and such, that is the husband of the petitioner number 2, refused to take the check, saying that rupees 7 lakh was very less amount and Obuk Meje should pay him more. He also said that if Obuk Meje is paying rupees 7 lakh, he should have paid much before and refused to receive the check. That is precisely what I am saying, my lord. Because then, my lord, will see the next paragraph. When both such and such and Obuk Mije, when nobody received the check, it remained with me for around next 6 months. The check was with him. Then, after around 6 months, he such and such asked about the check given by Obuk Mije and said to give the check to him. Accordingly, I searched the check and then handed over the check to him. Now, my lord, will see one little pause here, my lord. Now, my lord, while all this was happening, 6 months the check was with an officer of this court. Then he has given. At no point of time this clerical mistake was detected. Now, my lord, if a clerical mistake could skip your eyes, it may also skip my eyes. Now, my lord, so the statement, why I took your lordship to the statement of Tabit Tapak, because from the statement of Tabit Tapak, what transpired is this, my lord. This is not something which I am adding, which I am saying of my own, my lord. It is there on record that he refused to accept 7 lakh because he was expecting huge amount. That is exactly the same word used here, my lord.
That is 161 statement. No?
Yes, absolutely. Now, the charge sheet is at page number 61, my lord. Charge sheet, the same thing. It's based on all these things. And charge sheet was filed. Now, my lord, in between another criminal petition was filed for quashing of the FIR. But the same has to be withdrawn because charge sheet was filed in between. Page number 103. Because charge sheet was filed in between. Therefore, it has to be withdrawn, my lord. 104. It was withdrawn because the charge sheet was already filed. We challenged the FIR, but in between his charge sheet was filed. Therefore, we'll have to withdraw and then file a fresh, my lord. So therefore, my lord, this was withdrawn 104. Thereafter, my lord, at page number 105, that is the impugn order framing the charge, my lord. This is the order I am challenging, my lord. 105. Yes. Accused case is fixed for CC. Consideration of charges. Accused person Obuk Mije is present with learned counsel such and such. Learned APP such and such. Learned such and such had submitted that 465-193 party is made out. Learned APP has submitted that the offence is made out under 471 IPC and therefore charges may be framed against accused person under the penal code 465 has prayed that these are submissions. Hart perused the records upon hearing and perusal of the record. This court found that the show cause notice reply to ESC by the accused. He stated that he has paid 7 lakh to such and such, white check number such and such, and a copy of the said check is enclosed with this application before ESC. The same is also stated in the statement accorded under 161. However, in the original copy of the said check enclosed with the charge sheet, the date of the check is 2016. In the photocopy, 6 became 8 in the photocopy. Hence, it is seen that in the instant case, ingredients of section 465, 193 para 2 IPC are attracted and there is a strong presumption that accused person might have committed the offense under 465/193 para 2 IPC as alleged section 191 IPC is altered to 193 para 2 IPC and section 471. Ultimately, my lord, accordingly charges under 465/193 para 2 IPC is framed against the accused in separate sheet and annexed with the record. Charge framed is stated and explained to the accused person in the language in which. So, charge is framed under 465 forgery and 193 para 2 giving false evidence before him. Now, my lord, in the meantime, while the criminal proceeding was going on, I received an execution application notice at page number 107. My lord, is there?
Yes, sir. 107.
7. Now, my lord, the mail order became a decree. Now, execution notice. Probably tomorrow some attachment notice will also is awaiting, man. 107. Whereas decree holder has instituted an execution application in Mel Kabang decree decision dated such and such, you are hereby summoned to appear in this court in person or by a pleader duly instructed on the day such and such to show cause as to why execution should not be granted. Take notice that in the event of default of your appearance on the day before mentioned, the execution application will be allowed in your absence given under my sign. Now, my lord, I challenge the execution proceeding as well as the mail order and the entire proceeding before the village authority in a writ petition at page number 108.
482 means challenging the framing of charge.
Framing of charge, I am challenging FIR, charge sheet, framing of charge, everything.
FIR charge sheet and framing
Framing
of
of
charge.
charge.
That much.
That much. Now, this mail proceeding, I received an execution application notice. This execution execution proceeding along with the mail order is challenged in a writ petition at page number 108.
108.
Page number 109, there is a stay granted at page 110 and the matter is still pending adjudication. And there is a stay operating. So the execution proceeding is being stayed. The validity of the mail order is under challenge before this honorable court in an appropriate writ application. So, my lord, this is on the facts. Now, my lord, my argument, my lord, I am assailing this FIR, charge sheet and the order of framing charges primarily on 3 grounds. Ground number 1.
Please.
Assuming that the mail proceeding initiated by the extra assistant commissioner is valid in law, assuming, not admitting even for a moment. In that case, this FIR is hit by the provision of 195 CRPC. That is my first limb of argument. My second limb of argument is that the entire foundation, my lord, this FIR emanates from a proceeding which took place before an extra assistant commissioner in terms of the regulation of 1945. Now, my argument is this: the entire proceeding is flaunted because it lacks jurisdiction. Once the foundation falls, the FIR, charge sheet and all other thing is bound to fall. Once the foundation is removed, the entire consequential criminal proceeding will fall. My third limb of argument is it does not attract the ingredients of 463 IPC, for which the punishment is prescribed under 465 IPC. This is essentially what I am going to argue, my lord. My lord will kindly take up the CRPC. So my first argument is that it is hit by 195. Now, my lord, this argument I am making on a caveat. The caveat is that, my lord, the mail proceeding is valid. On an assumption that the mail proceeding is valid. My lord,
195. Yes.
190. My lord, before I take your lordship to 195, my lord, what 195 essentially says, my lord, in my limited understanding is this. It says that it enumerates certain offences, and offences under 463 is one of them, and 193 is also one of them. It enumerates certain offences, and it says that if these offences are committed before a public servant or a court of law, then the complaint has to be lodged by the said public servant or by the court through an officer of the court. The court will lodge a private complaint cannot be lodged if it is done before a court. So therefore, if it is a valid proceeding, if it is a valid judicial proceeding, then the FIR ought to have been lodged by the court.
Maybe a complaint case. We are complaint case, actually.
The procedure is in, your lordship is correct. The procedure is in 340. They have circumvented all proceeding. 195 circumvented, 340 circumvented, 341 circumvented, straight away come to 154 by a private person making an FIR before a police. Now, 195 reads as follows. No court shall take cognizance. No court shall take cognizance. I skip A, I come to B. Of any offense, B, clause B, subclause Roman 1. Of any offense punishable under any of the following section of the Indian Penal Code, 193 to 196. So 193 is one of the offense. 196, both inclusive. Rest section I ignore, my lord, because these are not the subject matter of the present case. When such offense is alleged to have been committed in or in relation to any proceeding in any court, or of any offences described in 463, or 463 is also one of the offense here, or punishable under section 471, section 475, or section 476. These are ignored. When such offences is alleged to have been committed in respect of a document produced or given in evidence in a proceeding in any court. Now, my lord, no cognizance will be taken except on the complaint in writing of that court or by such officer of the court as the court may authorize in writing in this behalf or some other court to which that court is subordinate. Now, my lord, the definition of court is in clause 3. In subclause B of subsection 1, the term court means a civil, revenue, or criminal court and includes a tribunal constituted by or under a central, provincial, or state act, if declared by that act to be a court for the purpose of this section. So these are judicial. Before 2014, the Kabang, the bodies which are constituted by the regulation of 1945 were deemed to be court, my lord, because the judicial proceedings took place in those courts, my lord, because those are constituted under a state regulation 1945. Therefore, my lord, what we have seen is that the charges of 193 and 463, 465, my lord, those charges, because 465 is the penal section, the definition is in 463. 463 and 193 are offences enumerated under 195, meaning thereby that for these offences, section 195 will come into play. Now, my lord, 195 full bench of the Honorable Supreme Court, followed by a constitutional bench judgment, 5-judge bench judgment, followed by few other judgments I'll rely during the course of my argument, which in categorical terms say 195 is mandatory. You cannot circumvent that proceeding. Now, my lord, before I take your lordship to those provisions, it would not be inappropriate to once refer to the provision of 340 CRPC. My lord, is there a 340? 340 is the procedure in cases mentioned in 195. Now, suppose somebody commits the offences enumerated in 195, then how the complaint is to be made? It is in 340. When upon any application made to it in this behalf or otherwise, any court is of the opinion that it is expedient in the interest of justice that an enquiry should be made into any offences referred to it in clause B of subsection 1 of 195, which appears to have been committed in or in relation to a proceeding in that court, or as the case may be, in respect of a document produced or given in evidence in a proceeding in that court, such court may, after such preliminary inquiry, my lord, there are certain requirements. A preliminary inquiry is envisaged by the Act, my lord. A preliminary inquiry, if any, as it thinks necessary, record a finding to that effect, make a complainant thereof in writing, send it to a magistrate of the first class having jurisdiction. That is precisely what had fallen from your lordship, that it would be treated as a complaint case. Take sufficient security for the appearance of the accused before such magistrate, or if the alleged offence is non-bailable and the court thinks it necessary to do so, send the accused in custody to such. Even they have the power to send him in custody. Now, my lord, what is important is 341. Against such finding recorded under 340 CRPC, the legislature gives me a right under 341 to prefer an appeal. I cannot be denuded of my right under 341. What essentially is being tried to, what essentially they are doing is that, my lord, my right under 341 is being strangulated, and they straightway approach the police, a procedure which is alien to the criminal jurisprudence followed in this country, my lord. My lord, I would fail in my duty if I do not bring to the light of this court another judgment. One important judgment, my lord. My lord, I'll take to all those judgments. It is there, my lord, in detail. I'll take, my lord. There is one judgment. I'm just, my lord, I'm just laying down the law. Broadly, I'm just laying down the law. My lord, I'll take your lordship. We'll just keep it in evidence for a few minutes. My lord, I'll take your lordship. The law is that section 195 is mandatory. To that effect, I'll take your lordship to the constitutional bench judgment, to the full bench judgment of this court. Now, there is one more parallel constitutional bench, full bench judgment, which says this, that with regard to the offense of forgery, if the document is forged outside the court and produced in the court, then the bar of 195 will not operate. That is what the full bench of the Supreme Court said in a judgment. There are later judgment where one had. Now, my lord, this case is titled as Iqbal Singh Marwa. No? Iqbal Singh Marwa, probably the learned friends would rely on that judgment, my lord. Iqbal Singh Marwa, this is one way. I'll first deal with this Iqbal Singh Marwa, my lord, then I'll go to the section. Now, Iqbal Singh Marwa says that if a document is forged outside the court and then produced, then the bar of 195 will not operate. The bar of 195 will only operate if the forgery is with respect to a document which is custodial legis, that is in the custody of the court. If the document which is forged is in the custody of the court, then the bar under 195 will operate. But if the forgery is committed outside the court, it will not operate. That is what Iqbal Singh Marwa says. Now, these are the parameters, my lord. Now I take to the decisions, and Iqbal Singh Marwa, I'll deal with Iqbal Singh Marwa, my lord, because I'll have to satisfy your lordship that Iqbal Singh Marwa will not be applicable in this case. And the cases which are decided based on Iqbal Singh Marwa, those cases are not applicable in this case. Because Iqbal Singh Marwa has followed the procedure of 340. Iqbal Singh Marwa, directly FIR was not there. My lord, I'll first deal with, my lord may take now the compilations of the cases. My lord rises at 1 o'clock for lunch, my lord.
Which number?
My lord. The first decision, this is para, my lord will kindly come to. My lord, before 195 CRPC, probably I would have to satisfy your lordship that whether your lordship can go into all this detail in an application under 482. Probably I'll have to satisfy your lordship on that, my lord. My lord, first I'll show the latest judgment on quashing, which says that your lordship can go into all this detail. I'll satisfy your lordship that all this detail, that your lordship may go into this detail. My lord, will kindly come to my compilation, page number 10. That is a very recent judgment. This is the Manu citation of 2023. I have given the Manu Patra citation. It starts from page number 1 of my compilation. It is decided on 8/8/2023, August 2023. I am relying on page number, para number 26. Page number 10. The pagination is on the right hand side top.
Yes,
Page number 10. Now, para 25 deals with Bhajan Lal. My lord, Bhajan Lal, I am not relying on Bhajan Lal. Everybody knows Bhajan Lal, my lord. Bhajan Lal, the paragraph, my lord, paragraph 102 of the Bhajan Lal, my lord. If prima facie, it does not constitute a cognizable offense. Number 1. Number 2, my lord, for wreaking vengeance, attended with mala fide, all this, my lord. Now, my lord, 2023, what Supreme Court says, page 10. My lord, there is a, my lord, in every quashing petition, my lord, we are faced with an argument that if the FIR prima facie discloses an offense, this court will not quash it. This is the common, my lord, argument which we have come across in a 482 present, that the rest of the part is for the investigating agency to decide. Only if it is prima facie does not do. But the law have changed drastically, my lord. It has undergone a paradigm shift, my lord. Para 26, page 10. At this stage, now this is on law, my lord, this is not on facts. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent power under 482 of the Code of Criminal Procedure or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or the criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with an ulterior motive for wreaking vengeance, then in such circumstance, the court owes a duty to look into the FIR with care and a little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR complaint is very well drafted with all the necessary pleadings. The complainant would ensure that the averment made in the FIR complaint are such that they disclose the necessary ingredient to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averment made in the FIR alone for the purpose of ascertaining whether the necessary ingredient to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averment, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under 482 of the Code of Criminal Procedure of the Constitution or 226 of the Constitution, need not restrict only to the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation, registration of the case, as well as the material collected in the course of investigation. So, my lord, probably, my lord, here, my lord, the Supreme Court says that just because the FIR, because, my lord, if I decide to take on Mr. X, I will ensure that all the necessary ingredients of the offense are there. Therefore, the Supreme Court says, not only the language, go to all the circumstances leading to the initiation of the FIR or registration of the case. Now, my lord, one judgment I could lay my hands on another recent judgment. Somehow, my lord, after making this compilation, I found this judgment. I'm relying on this, my lord, will kindly see. Para 9, 10, and 11, Supreme Court, my lord. On similar lines. It is same case only, yeah. Same case, no?
19 and 11.
Yes, 9, 10, and 11. It also is para 9, 10, internal page number 740. Para 9. At this stage, we'd like to observe something important. Whenever an accused comes before the court invoking either the inherent power under 482 or the extraordinary jurisdiction under 226 to get an FIR or the criminal proceeding was essentially on the ground that such proceeding are manifestly frivolous or vexatious. Same line, my lord. Same things. We say so because once the complainant decide to proceed, same thing, my lord. It is reiterated. So, my lord, therefore, my lord, in view of this judgment, probably, my lord, this counsel was correct in taking your lordship to the circumstances which led to the initiation of this case, my lord. Those are the mail meetings, notices, and other things, my lord. But therefore, my lord, in my limited understanding, my lord, probably your lordship under 482 can go into all this. There is no bar as such. Now coming to 195. This is a full bench judgment by 3 judges bench of the Honorable Supreme Court. My lord, may kindly come to page 13. 1-3. It starts from page 12. Page 12, but I am relying on the para 3 last paragraph. Yes, the paragraph, the last paragraph of para 3, my lord, it quotes section 195 and then it says, the word of the section the word of the section, namely that the complainant has to be in writing by the public servant concerned, and that no court shall take cognizance except on such a complaint, clearly shows that in every instance, the court must be moved by the appropriate public servant. We have to decide, therefore, whether the Talisdar can be said to be the public servant concerned, and if he had not filed the complaint in writing, whether the police officer in filing the charge sheet had satisfied the requirement of 195. The words "no court shall take cognizance" have been interpreted on more than one occasion, and they show that there is an absolute bar against the court taking cognizance of the case except in the manner provided by the section. So, my lord, for an offense enumerated in section 195 CRPC, this operates as a bar. Then, my lord, the page 14, the line which starts with "in our opinion," right hand side, "in our opinion." In our opinion, this is not a due compliance with the provision of that section. What the section contemplates is that complainant must be in writing by the public servant concerned, and there is no such compliance in the present case. The cognizance of the case was therefore wrongly assumed by the court without the complaint in writing of the public servant, namely the Talisdar in this case. The trial was thus without jurisdiction ab initio, and the conviction cannot be maintained. The trial was without jurisdiction ab initio, from the inception. Now, the second is another 5-judge bench judgment, my lord, page number 15, your lordship will see. This is a page 15, 5-judge bench judgment, constitutional bench judgment. 1, 2, 3, 4, 5, 5-judge bench judgment. I take your lordship to page 17, para 6. Para 6. That takes us to section 195 of the Code of Criminal Procedure. It is well known that section 195 provides an exception to the ordinary rule that any person can make a complaint in respect of the commission of an offense triable under the CRPC. Section 4H of this code defines a complaint as meaning the allegation made orally or in writing to a magistrate, with a view to his taking action under the code that some person, whether known or unknown, has committed an offense, but does not include the report of a police officer. This definition shows that any person can make a complaint in respect of the commission of an offense. Section 190 requires that the magistrate to whom a complaint has been made should take cognizance of the said complaint subject to the provision of the said section. The general rule is that any person can make a complaint, and section 195 provides for an exception. Section 195, with which we are concerned, provides that no court shall take cognizance of any offense punishable under the section therein mentioned when such offense is alleged to have been committed in or in relation to any proceeding in any court, except the complaint in writing of such court or of such other court to which such court is subordinate. Amongst the section mentioned are 193 and 228 IPC. The effect of this provision is that if an offense is alleged to have been committed either under 193 or 228 IPC, and it appears that the said offense was committed in relation to any proceeding in any court, it is only if the said court or the court to which it is subordinate makes a complaint in that behalf that cognizance will be taken of the said complaint. A person cannot make a complaint in respect of the alleged commission of any of the offenses specified in 195(1)(b. That is its plain effect. Now, para 13 defines judicial proceeding, my lord. I need not go much into that, my lord, because admittedly this proceeding is assuming if it has jurisdiction, then the mail proceeding is a judicial proceeding because it decides the juror relation between the parties, my lord. Then page number 30, my lord, is another decision. 2019. Now, my lord, Iqbal Singh Marwa is of 2005. That the other judgment which speaks that outside court. Now, this is 2019. This judgment, page number 30. Para 16.
Para 16.
I'll go to para 14 and then I'll come to para 14. Section 195 of the Code of Criminal Procedure lays down a rule to be followed by the court, which is to take cognizance of an offence specified therein, but contains no direction for the guidelines of the court, which desires to initiate proceeding in respect of an offence alleged to have been committed in or in relation to a proceeding in the later court. For that purpose, one must turn to 340 CRPC, which requires the court desiring to put the law in motion to prefer a complaint either suo moto or an application made to it in that behalf. Now, my lord, may come to page para 16, 16. Section 340 of the Code of Criminal Procedure make it clear that a prosecution under this section can be initiated only by the sanction of the court under whose proceeding an offence referred to in section 195 1B has allegedly been committed. The object of this section is to ascertain whether any offence affecting administration of justice has been committed in relation to any document produced or given in evidence in court during the time when the document or evidence was in custodia legis, and whether it is also expedient in the interest of justice to take such action. The court shall not only consider prima facie case, but shall also see whether it is in or against public interest to allow a criminal proceeding to be instituted. Para 19. This court in so-and-so has clearly held that private complaints are absolutely barred in relation to an offence said to have been committed under section 193 Indian Penal, and that the proceeding prescribed under 195 of the Code of Criminal Procedure are mandatory. My lord, this is more in tune of section 197. This is more in tune with section 197 of the CRPC. To prosecute a public servant, we need a sanction from the government. Similarly, here, if you want to prosecute with respect to an offence committed during a judicial proceeding, you need the sanction of the court. Therefore, it has to be initiated from the court. The other judgment, again 2016, page 38.
38.
Page 38. Para 41 to 47. Para 41 to 47, I am relying.
41.
41. Para 41, just to show that the genus of the debate is as the genesis of the debate is rooted in 195 of the code, a detailed reference thereto is indispensable. For convenience, 195 as a whole is extracted here in the page 58, the last paragraph. The last paragraph. Page 58, my lord, is there. Last paragraph. Section 195(1)(b) of the code,
Page 58.
58, right hand side, page 58.
58. Page 58, last paragraph.
Yes. We start with section 195. Section 195(1)(b) of the code, which is relevant for the instant pursuit, prohibits taking of cognizance by a court vis-a-vis the offences mentioned in the three clauses 1, 2, and 3, except on a complaint in writing of the court when the offences are alleged to have been committed in or in relation. Well, the words are important. In or in relation to any proceeding before it, or in respect of a document produced or given in evidence in such a proceeding, or by such officer of that court as it may authorize in writing, or by some other court to which the court is subordinate. A patently regulatory imposition in the matter of lodging of a complaint for such offences is discernible assuredly to obligate frivolous and wanton complaint by all and sundry. So that wanton complaints by all and sundry are discouraged. Para 46. That the provision of section 195 of the code are mandatory, so much that non-compliance thereof would vitiate the prosecution and all consequential orders, has been ruled by this court, among other, in such and such. My lord, these all judgment are post 2005, Iqbal Singh Marwa. Page para 46, there is a reference of para 7 of another judgment of 98, and I'm just relying on the last 3 lines of that para of another judgment. My lord, is there para, sir? It is well recognized canon of interpretation that provision carving the general jurisdiction of the court must normally receive strict interpretation unless the statute or the context required otherwise. Meaning thereby, my lord, to whatever little I understand, my lord, that since 195 is an exception to the general rule that any person can lodge an FIR or initiate a complaint, since it is an exception, therefore, it has to be strictly interpreted and strictly adhered to. Para 47. There is thus no escape from the proposition that for a valid complaint under section 195 of the code, the mandate thereof has to be essentially abided, and as is easily perceivable, this is to prevent frivolous, speculative, and unscrupulous allegation related to judicial proceeding in a court, lest the process of law is abused and public time is wasted in avoidable litigation. Para 48. Now, my lord, para 48 is in relation to the facts of that particular case, because it was under an Income Tax Act, my lord. No, my lord.
Yes.
My lord. I'm really, can I continue after the lunch minutes? Only
Yeah.
because-
Act 2.
Act 2.
My lord,
Yes.
actually, your Honor, today, my lord, I come for 5 minutes late.
Which one?
Actually,
This one?
yes.
Take over 2.
Actually, Your Honor mentioned actually today I come 5 minutes late due to my daughter's exam. So today I file one IA very urgent because day after tomorrow we have case at CGM.
Listing of places.
Yes.
Tomorrow then?
No, actually tomorrow is holiday body vote. Case is fixed CGM at Alo on 7. To the last item maybe.
7.
No, Your Honor, today case CGM court fixed on 7 on at Alo, Western District. So actually, at least I file.
3800.
Yes, yes, if time permit. Please, my lord.
How much for 7? No, it's difficult
My
because
lord.
we're taking up this cases.
Actually, I'm waiting.
7?
Yeah, my lord. 7 is actually the fixed on at least.
Possible.
Yes.
Yes.
It's item number 5.
5.
During
I'm already over.
yes, I take on this before I was at the only present price is there on That may be, that may kindly be continued in item number 5.
It's taken there. no? Order, first was taken there, no? It's taken, entry is there, continue.
Your Lordship,
Thank you, Lordship.
Your Lordship, maybe last. Online.
May I please, my lord? My lord, I beg to mention item number 15 and 16, today's Passover item, my lord.
Already order has been passed.
Yes, my lord, this matter may be Passover,
Passover for time being.
time being, my lord.
As opposite counsel was on leg at the court number 1. It was Passover for time being.
15 and 16.
Yes, my lord.
15 and 16, no order has been taken, no?
Yes, my lord. Can it be list 7th of this month?
After 2 weeks.
No,
No,
my
no,
lord,
7.
there is- I am for the applicant, my lord. I am for the petitioner, yeah. They are for the opposite party. So,
Then nobody is there.
my lord, this matter may be taken up on 7th, my lord.
7.
Otherwise, I am ready to the, my lord.
You're for the appellant.
Yes, I am for the appellant, my lord.
15 and 16.
Yes, my lord. I have filed the IA 7th of 2024. My lord, subject matter of the case is the lane, my lord. And during the pendency, this RSA, they started constructing permanent structure, my lord. So, my lord, there is urgency, my
My
lord.
lord, matter may be list on 7 of this month,
7-2.
7,
7, 2 years.
7.
Monday, my lord. I think.
And 16 on the prayer of request of 7. 15 and 15. I think your argument is over, no?
No, no,
No.
no, there are 3 limbs of argument. I have just completed 1 limb of argument. I'll not take much time, my lord, only hardly 15 minutes, I'll wrap it up.
Okay, that's all right.
My lord, nowadays, my lord, the presumption is of guilt, not of innocence. Therefore, my lord, we need to prove our innocence, my lord.
Yes, please.
So therefore, my lord, my first limb of argument that assuming the mail proceeding is valid, because, my lord, this photocopy of the check was submitted in pursuance to an order passed by a mail and in pursuance to a show cause notice issued in furtherance to a mail proceeding, my lord. So if we assume that it is true, then that it has jurisdiction, then it is hit by 195. Now, my second limb of argument is that the mail proceeding is dehors the notification passed by the government of Arunachal Pradesh in consultation with the Honorable High Court.
In the year 2014.
14, the said notification is dehors of the division bench order, which has a reflection in a single bench order, which I have
Repeat, please.
and
Thank
proceed.
you.
Now, my lord, I will show that once the foundation of a criminal case falls, the entire edifice is bound to fall. My lord, my lord will kindly come to my compilation, page number 90.
19.
90.
90. 90, yes.
My lord is there. Now, my lord, this is the judgment. My lord.
This is judgment.
Yes, of the Supreme. No, no, my lord, compilation.
This is your
No, no.
compilation.
That is the petition. Page 90. This is the judgment, my lord, Supreme Court judgment. My lord will straight away come to page 117, para 17. Para 70, 70, my lord. The FIR unquestionably is an inseparable corollary to the impugned order, which are a nullity. Here the FIR is a corollary of a proceeding in the mail, which in my respectful submission is a nullity. Therefore, the very birth of the FIR, which is a direct consequence of the impugned order, cannot have any lawful existence. My lord, is there, my lord?
Yes, sir.
Will have no lawful. The FIR itself is based on a preliminary inquiry, which is in turn based on the affidavit submitted by the applicant who had filed the petitions under 482 Code of Criminal Procedure. 72 is the law laid down. Para 72. It is a settled legal proposition that if initial action is not in consonance with law, all subsequent and consequential proceeding would fall through for the reason that illegality strikes at the root of the order. In such a fact situation, the legal maxim sub leto fundamento cadit opus, meaning thereby that foundation being removed, structure, work falls, comes into play and applies on all courts in the case. So once the foundation goes, the foundation is the mail proceeding, which is stayed before the Honorable High Court, the execution proceeding, which is a challenge. So in terms of the notification and in terms of the orders which I have already submitted, the mail proceeding has got no legal sanctity. The FIR has a direct nexus with the mail proceeding because the FIR was submitted in response to a show cause notice which was issued in terms of the mail proceeding. So once the mail proceeding goes, once the foundation is removed, the entire prosecution ought to fall, and Supreme Court says it is a settled legal proposition. Para 72. Now, my lord, we will kindly come to IPC section 463. That's my final limb of argument, my lord. Section 463. Because 193, my lord, that is
460.
463. My lord, whoever, my lord, is there at 463 definition of
463.
whoever makes any false document or false electronic record or part of a document or electronic record with intent to cause damage or injury. My lord, I take a pause here. My lord, by manipulating or forging a photocopy of a check, check is in the possession of the other party. My lord, before parting with my submission, the private respondent filed an affidavit. Now that makes my case clear now. My lord will kindly come to the affidavit filed by the private respondent and to deal with it. My lord is there. In their affidavit, they have admitted all what I have submitted. My lord, before I take to the relevant paragraphs of the affidavit, my lord, charges here is framed under 193 and 465.
265.
465 and 193. Now, my lord, will see para 10, what they have submitted, page number 4 of their affidavit, para 10. That with regard to the statement made in paragraph 9, 10, 11, 12, and 13 of the petition, my lord, this affidavit is on oath.
There is a affidavit in opposition.
Yes,
by
I am
the
reading
court.
affidavit in opposition.
Affidavit in opposition.
Yes, para 10.
Para 10.
It is their pleaded case before this court, my lord.
With regard to.
With regard to the statement made in para 9, 10, 11, 12, and 13 of the petition, the deponent denies everything not borne out of record and the petitioner is put to sleep. An attempt is made to divert the focus from the jurisdiction of the village authority from the fact that even if the jurisdiction is disputed, it will not change the fact that an offense has been committed. Thus, while an improper, my lord, kindly take note, my lord. Thus, while an improper male kabang may have a bearing upon the civil right of the deponent, it cannot prevent the criminal machinery from prosecuting the petitioner for his act if they constitute an offense. Therefore, they are, in other words, my lord, they are saying that the male kabang, improper male kabang. Now, my submission is that no criminal case can be initiated from an improper male and kabang in view of the last judgment which I have relied on, because once the foundation falls, the entire edifice falls. So this, they indirectly admit that thus, while an improper male kabang may have a bearing upon the civil right, so they also know that this mail order or this mail proceeding is dehors the law, my lord. My lord will kindly come to their affidavit at page. They are of the view that still the section of that still the offense of cheating probably survives. They are of the view that the offense of cheating is still surviving. But my lord, charge has been framed only under 465 and 193, and they have not challenged the order of consideration of charges. My lord will kindly see para 15 and 16. That with regard to the statement made in paragraph 18 of the petition, the deponent humbly submits that it is only the FIR was lodged against the alleging cheating and forgery. That he stated, claiming that the two different dates on checks were caused due to oversight and bona fide mistake vis-a-vis after initiation of criminal proceeding against him. Thus, it is reiterated that his conduct reveals cheating and forgery. My lord, I skip this. Para 16 will see. That with regard to the statement made in para 19 of the deponent begs to state that sufficient material exists for framing of charge under 420, 467, 468, 471. My lord, I have not understood the meaning of this. Sufficient material exists, then why they have not challenged the order of framing of charges? They are not on 465, they are not on 192. Because they know that 192 and 465 are the offenses under 195. Now, my lord will see their statement on oath at para 19.
Para 19.
19.
Yes.
The bar would have, I'm just keeping this, the first line, my lord, because it speaks of the corresponding paragraphs in the criminal petition. I start with the bar. The bar would have been attracted if the petitioner had forged a document which was in custody of a court. However, he has submitted a forged document in his reply. How do he know, my lord? It was in the custody of the court for 2 years. Furthermore, it needs to be stated that apart from the forged document, here comes, my lord, that apart from the forged document submitted, the petitioner has cheated the document. My lord, cheated the document, cheating, there is no charge of cheating. Thus, this offense will survive as it is distinct from any offense which may have been committed under 191 of the IPC. So this will survive. He's saying cheating will survive. But probably the respondent has lost sight of the fact that no charge is framed under cheating and they have not challenged the order of framing of charges. They are time and again harping on cheating. Then comes para 20. That perusal of the impugned affair will reveal that the offense of cheating and forgery was committed before Mel Kabang proceeding was initiated. Hence, it is not the deponent's case that the petitioner should be punished for submitting. My lord, I don't, my lord. if I understand the plain language correctly, they are saying that an offense of cheating and forgery was committed before the Kabang decision. How do they come to this finding? Because after the Kabang decision, when the order of the Kabang was placed before the extra assistant commissioner, the extra assistant commissioner issued a show cause notice. In reply to this show cause notice, that check came into being, that photocopy check. These are submissions made in abstract. Hence, it is not the deponent's case. Now, this is very important, my lord. These are all on oath. Hence, it is not the deponent's case that the petitioner should be punished for submitting a false document. Matter ends there. They don't want me to be prosecuted for submitting a false document. Therefore, the bar under 195 cannot be used. Probably they are under the impression that charge has been framed under 420. And therefore, they are saying that if 463 and 491, the schedule offense under 195, even if those goes, that's the charge of cheating will survive. They have clearly admitted. Hence, it is not the deponent's case that the petitioner should be punished for submitting a false document in court. It is not their case. My lord will kindly come to para 22.
Para 23.
Para 22. The second line, which starts with das. The fourth line, which starts with das on the right hand side. Das while an improper mail, again reiterating that the mail is improper. Das while an improper mail, kabang, may have a bearing upon the civil right of the deponent, it cannot prevent the criminal machinery from prosecuting the petitioner of this act. Now, my lord, last para 24, my lord will see. The sufficient material exists for framing charges under 420, 467, 468, 471. No charge is framed under this section. He is not aggrieved by the charge framed under 465 and 193. He is not resisting that. Again, reiteration, it is not the deponent's case that the petitioner should be punished for submitting a false document in court. Admitted. So the private respondent is supporting the case of the petitioner. In clear terms, they are supporting the case of the petitioner. Now, my lord, my lord, this makes my case relatively easier, my lord. Page 9, my lord will see their abutment in paragraph 24. Continuation of para 24 is at page 9. I see further, if a bar exists in regard to one section, a court can take cognizance of the other section and quashing of the entire charge sheet is not warranted. Now, my lord, I agree to this. If bar, so therefore the bar exists in respect of 193 and 465. A court can take the other section, no cognizance has taken against the other section like 420, 471. Filed by the deponent, there is an affidavit attached to it. That is the complainant, informant.
Prior to framing of charge, I think.
No. Yes, in this criminal petition, they filed it. They filed it before this court. In this criminal, this is shown on 30th of October 2023. And charge frame order is mobile. And charge was framed on 16/6/2023. 16/6/2023. And this affidavit is filed on 30 October. June, in the month of June, charge was framed. In the month of October, they are filing this affidavit before the High Court when I have come for quashing. So therefore, clearly, my lord, they are admitting my case. They are saying that cheating will survive, other offense will survive, 471 will survive. Where is the question of 471? If it survives, then they ought to have challenged it. And they have already admitted that the improper mail meeting, and they are not even aggrieved by the fact that I have submitted a forged document, which I am categorically denying. Page 28, sorry, para 28, page 10. Again, they are saying sufficient material for 420, 467, 468, 471. Nowhere they are mentioning 193 and 465, the offenses under which the charge has been framed. So according to them, no material for 465 and 193. Now, my lord. Now, I am sure, my lord, my friend would rely on that Iqbal Singh Marwa and try to make out a case that here the forged document is, the document allegedly was forged before it was produced in the court, and therefore the bar under 195 will not come because the forgery is done. My lord, they became the judge of their own cause, my lord. If that be so, then there has to be a preliminary inquiry under 340. 340 envisages an inquiry, and a right to appeal is given to me under 341. You cannot circumvent that. My lord will kindly take up this.
Your Lordship, the prosecution side will also rely this judgment on a later.
Huh? 33.
Marwa.
This is the judgment, my lord. I'll just show, my lord, what happened in this case, my lord. In this case, 195 was not circumvented. It was followed. My lord, I'll just indicate that particular paragraph. 340 इसलिए हमारा वो मार्किंग तो इम्पोर्टेंट था. हाँ, पैरा 33 में जो ना उसको पहले भी किया जहाँ पे 340 था. Because an application under 340 was filed. Now, once an application under 340 was pending and it was not acted upon, therefore they filed a criminal complaint. And in that background, the Supreme Court has laid down that if the forgery is outside, then the bar under 195 will not come. That observation, your lordship will find at para 33, that observation. Provided that is an SCC citation. That is an SCC citation. SCC. Para 33.
33. Yeah.
In view of the discussion made above, we are of the opinion that Sachindra Nandan Singh has been correctly decided, and the view taken therein is the correct view. Section 195 1B2 CRPC would be attracted only when the offence enumerated in the said provision have been committed with respect to a document after it has been produced or given in evidence in a proceeding in any court, that is during the time when the document was in custodial lease. That is. Now, in my case, precisely that the FIR is of 2021, the photocopy of the document was in custody of the court from 19 to 2021. And my lord, para number 3, my lord will kindly come to para number 3, that in this case 340, the complainant initially resorted to 340. Para number 3, thereafter the respondent moved. Yes, my lord.
3.
Para 3, my lord will see. I'm just reading this. The facts of the case may be noticed in brief. Appellant 1 and 2 are, my lord, what happened here in this case, my lord? The brother of a deceased, 2 brothers of a deceased filed a probate case by forging a will and submitting it in the court. A probate case was filed by the brother of the 2 deceased. It was contested by the widow and the son of the deceased. Now, subsequently, it was discovered that the will which was produced to get a probate, that will was forged document. And, my lord, this line is very important, my lord. Thereafter, the respondent moved an application under section 340 CRPC. Now, my lord, the law is this, that if forgery takes place before, then 195 will not come. But 193 in all circumstances will go. 193 charge, FIR under 193 cannot be filed by any private individual. To that respect, I don't think there is any dispute in the bar. It is only with respect to 463. 463, there is clear finding that 190, it is a schedule offense under 195, number one. Number two, 2019 June, this was placed before the photocopy was given in a reply to a show cause notice. In 2021, this comes up. This FIR comes up, and in the FIR itself, she writes that 195 will not be. Because of 195, I have not lodged the FIR, my lord. He could have made an application under 340 before the magistrate. Let there be a preliminary inquiry to the effect that whether it was forged before or prior, because that makes a hell lot of a difference in the subsequent proceeding. My lord, my client is a class 1 graduated officer working in a department, veterinary department of the state. To drag him in a criminal court for a sum of rupees 5 lakhs, which I had already said that if you want the check value can come. To appear before a criminal court, my lord, it is not only harsh, my lord, it is demeaning his stature in the society as well, my lord. That's my submission, subject to what the other side says, my lord. I am so grateful.
May it please your lordship.
Come to the point on first 195.
195. It's very clear, your lordship. The embargo under 195 will not apply in this case, your lordship. Why? Because, your lordship, my brother has pointed out the Iqbal Singh Marwa.
Yes.
Your lordship, Iqbal Singh Marwa case has come from the other earlier judgment. I will rely on that judgment, wherein the FIR is also registered.
Yes.
And your lordship, so far as for invoking the under 195, 340, your lordship, the preliminary inquiry is also not required. This is settled. But in this case, your lordship, the question of 195 not at all comes, your lordship. Your lordship, your lordship, before I rely on this judgment, your lordship, the fact here is, your lordship, prior to the filing of the forged document before the executive magistrate, this document is produced before this honorable court also, your lordship. When they have filed a writ petition challenging the order of the learned EAC while exercising his civil jurisdiction under AFR, the accused has produced that forged check before this honorable court also on oath. I will come to that, your lordship. Now, your lordship, whether embargo under 195 will operate in this case or not, let us see, your lordship. Your lordship may kindly personally come to your lordship fact. Let us see the fact in this case, what exactly has happened in para 2.
Para 2 of? Yeah,
This judgment,
Marwa?
not your lordship, the Sachinder Nan Singh. Yes, your lordship.
Para 2.
Para 2, your lordship. May I read? A complaint was filed by second respondent Lal Naren Singh in the Court of Chief Judicial Magistrate alleging offence inter alia under section 468, 469 and 471 of the Indian Penal Code on the fact that the appellant had forged document, certified copy of Jamabandi, rent roll and produced it in the court of the executive magistrate, which was then dealing with proceeding under section 145 of the code. Chief Judicial Magistrate forwarded the complaint to the police as provided in the section 156(3). Police registered an FIR. Here, your lordship, FIR. On the basis of the said complaint and after investigation laid a charge sheet against the appellant for those offences, the Chief Judicial Magistrate took cognizance of those offences and issued process to the accused. Appellant then moved Patna High Court under section 482 of the code for quashing of the prosecution on the main ground that the magistrate could not have taken the cognizance on the said offence in view bar contained in 195 1B2 of the code. Before the High Court, appellant cited the decision of this court in Gopal Krishna Menon Supra, but a single bench of the High Court dismissed the said petition filed under 482 by relying on the later decision of this court in Mahadev Bapuji Mahajan and another versus State of Maharashtra. Appellant therefore filed this appeal by specially. Therefore, your lordship, here in this case, the Honorable High Court has not interfered with the matter. Why? Because, Your Lordship, the Honorable Supreme Court has upheld the order passed by the Honorable High Court. Your Lordship may kindly come to para 23. Last page, Your Lordship. Yes, Your Lordship. The sequitur of the above discussion is that the bar contained in 195(1)(b)(2) of the code is not applicable to a case where forgery of the document was committed before the document was produced in the court. Accordingly, we dismiss this appeal. Your Lordship, it has been clearly held. The document has been forged outside the court and then it was produced. It is not a case, even in the present case, it is not a case where the document was produced before the court and subsequently it has been forged. No, this is not the case here. Here is a case, the document has been forged outside, then it was produced before the court. Therefore, Your Lordship, the question of embargo bar under section 195 is not at all come in this case, Your Lordship. The FIR, therefore, clearly, Your Lordship, FIR can be filed before the investigation authority, and learned court below has a jurisdiction to take cognizance of the matter, which the learned court below has done in this case, Your Lordship. And now, Your Lordship, I will rely the Marwa matter again, Your Lordship, which my brother has relied. Your Lordship may kindly come to para 10 first, Your Lordship. Yes, Your Lordship. Here, Your Lordship, there is a two-part in the 195 as well, Your Lordship. Yes, Your Lordship. The scheme of the statutory provision may now be examined. Broadly, section 195 CRPC deal with three distinct categories of offense which have been described in clause A, B1 and B2. And they relates to 1, contempt of law authority of public servant; 2, offense against the public justice; and 3, offense related to document given in evidence. Clause A deal with offense punishable under section 172 to 188, which occur in chapter 10 IPC, and the heading of the chapter is of contempt of lawful authority of public servant. These are offenses which directly affect the functioning of or discharge of lawful duties of public servant. Clause B1 refer for offense in chapter 11 of IPC, which is headed as of false evidence and offense against public justice. The offense mentioned in this clause clearly relates to giving or fabricated false evidence or making a false declaration in any judicial proceeding or before a court of justice or before a public servant who is bound or authorized by law to receive such declaration, and also to some offense which have a direct correlation with the proceeding in the court of justice, section 205 to 2011 IPC. This being the scheme of two provision or clauses of the section 195 is that the offense should be such which has direct bearing or affect the functioning or discharge of the lawful duty of the public servant or has a direct correlation with the proceeding in a court of justice. The expression when such offense is alleged to have been committed in respect of a document produced or given in evidence in a proceeding in any court occurring in clause B2. Clause B2 is different, Your Lordship. Should normally means commission of such an offense after document has actually been produced or given in evidence in the court. This situation or contingency where an offense as enumerated in this clause has already been committed earlier and later on the document is produced or is given in evidence in court does not appear to be in tune with clause A1 and B1. And consequently, with the scheme of section 195 CRPC, this indicates that clause B2 contemplates a situation where the offenses enumerated therein are committed with respect to document subsequent to its production or giving in evidence in a proceeding of any court. Now, Your Lordship may come to para 25. Yes, Your Lordship. Yes, Your Lordship. This case especially deal with the section 195 1B2, where section 465, whether under section 465, Your Lordship, 195, when 195, the bar under 195 will operate. An enlarged interpretation of section 195 1B2, whereby the bar created by the said provision would also operate where after commission of an act of forgery and document is subsequently produced in the court is capable of great misuse. As pointed out in Sachinder Nan Singh, Your Lordship, which I have relied, after preparing a false document or committing an act of forgery, a person may manage to get a proceeding institute in a civil, criminal, or revenue court, either by himself or through someone set up by him, and simply file the document in the said proceeding. He would thus be protected from prosecution, either at the instant of a private party or the police until the court, where the document has been filed itself, choose to file a complaint. The litigation may be prolonged one due to which the actual trial of a person may be delayed indefinitely, such an interpretation would be highly detrimental to the interests of society at large. 26. Judicial notice can be taken of the fact that the court are normally reluctant to direct filing of criminal complaint, and such a course is rarely adopted. It will not be fair and proper to give an interpretation which lead to situation where a person alleged to have committed an offense of the type enumerated in clause B2 is either not placed for trial on the account of non-filing of complaint, or if a complaint is filed, the same does not come to its logical end. Judging from such an angle will be in consonance with the principle that an unworkable or impracticable result should be avoided. In a statutory interpretation by Francis Bennion, 3rd edition, para 313, the principle has been stated in the following manner. The court seek to avoid a construction of an enactment that produce an unworkable or impractical result, since this is unlikely to have been intended by Parliament. Sometimes, however, there are overriding reasons for applying such a construction. For example, where it appears that Parliament really intended or the literal meaning is too strong, Your Lordship. Now, Your Lordship may come directly to para 33. In view of the discussion made above, we are of the opinion that Sachinder Nand Singh has been correctly decided, and the view taken therein is correct view. The said provision, the section 195 1B to CRPC would be attracted only when the offense enumerated in the said provision have been committed with respect to the document after it has been produced or given in evidence in proceeding in law, that is during the time when document was in custody legis. Therefore, Your Lordship, for example, Your Lordship, if today they file an affidavit, Your Lordship, on record, Your Lordship, and they produce certain document in it, and they manipulate it or forge it, then embargo will operate 195. But from outside,
With the petitioner. No?
yes, Your Lordship, whether 465 will applicable or not, I will come to that, Your Lordship. Now, in this case, Your Lordship, they have forged the document outside the court, and it was produced before the court with an intention to get benefit out of it, just to project their case as if they have already produced the check to the concerned person in discharge of their liability, Your Lordship. That is one part, Your Lordship. So, Your Lordship, considering these two judgments, Your Lordship, it is very clear that if the document has been forged and later it has been produced, then embargo under 195 will not operate, Your Lordship. And the same fact here, he forged it and produced. Now, Your Lordship, Your Lordship, attracting section 463 of IPC, what are the ingredients? What are to be looked into, Your Lordship? On that, Your Lordship, I will rely two judgments, one from the, Your Lordship, Division Bench of the Patna High Court, and then I will come to the Supreme Court judgment, Your Lordship. What ingredient has to be looked into, Your Lordship? Whether it was original one, whether it is a secondary one, that cannot be looked into, and while considering whether the offense ingredient is fulfilled or not, Your Lordship. Your Lordship may kindly come to this judgment is reported in 2018 CRLJ 1449. In the, Your Lordship, Patna High Court judgment, Your Lordship. Division Bench, Faidi Federal, son of Aziz Federal versus State of Bihar through its Home Secretary, Your Lordship. Your Lordship may kindly come to para 11 and 12. Above 11, Your Lordship, the section 463 has been given. 11, Your Lordship, may I read it? Yes. From a reading of the definition of forgery as prescribed under section 463 of the IPC, it would be evident that in order to attract the offense of forgery, the following ingredient would be necessary. 1. The document or part of the document must be false. It must be, second, it must have been dishonestly or fraudulently in one or of the three modes specified in section 464, and 3, it must have been made with intention, Your Lordship. A, to cause damage or injury, 1, the public or any person, or to support any claim or title. There he was claiming that he has paid the amount, Your Lordship. C, to cause any person to part with property, or to cause any person to enter into an express or implied contract, or to commit fraud, or that fraud may be committed. 12. Thus, it would be evident that to constitute the offense of perjury, making of a false document is an essential ingredient. Here, Your Lordship, even in this case, Your Lordship, I will come to that, Your Lordship, reply they have filed, what they have taken stand there. I will come to that, whether that statement given in the particular representation will constitute this ingredient or not, Your Lordship. I will come to that, Your Lordship. And now, Your Lordship, I will rely the judgment of Honorable Supreme Court rendered in, Your Lordship, 2011-5 SCC 708, Sushil Suri versus CBI and another, Your Lordship. Your Lordship, may kindly come to para 18. The same aspect has been reiterated, Your Lordship. Your Lordship, at this stage, before I read, Your Lordship, I'll pause for the moment, Your Lordship. At this stage, we shouldn't forget that this is a 482 application, Your Lordship, where court has to see whether prima facie material is there against the accused to proceed with the case. There is no any requirement of, Your Lordship, embark into the material meticulously, Your Lordship. Your Lordship, now may kindly come to para 18.
Right.
Yes, Your Lordship. Similarly, the definition of forgery in section 463 IPC is very wide. The basic element of forgery are: 1, the making of false document or part of it. Your Lordship, it says making of false document, Your Lordship. And such making should be with such intention as specified in section. To cause damage or injury to the public or any person, to support any claim or title, to cause any person to part with property, to cause any person to enter into an express or implied contract, to commit fraud or that fraud may be committed. As stated above, in the instant case, more than sufficient circumstances exist suggesting the hatching of criminal conspiracy and forgery of several documents leading to commission of the aforementioned section. We refrain from saying more on the subject of the juncture, lest may cause prejudice. Here, Your Lordship, making of document, Your Lordship. It also it should be with the intent, Your Lordship, to commit or to, Your Lordship, to support the claim. So now, Your Lordship, to substantiate whether there was a material, prima facie material of the allegation or not, will directly come to the, Your Lordship, his reply, where he has committed, alleged to have committed the offense.
What you have filed, no? You have submitted that reply.
Yes,
That
Your
is your reply.
No, its reply is filed by the, Your Lordship, private respondent, Your Lordship. We are relying on their document only, Your Lordship. The main petition, Your Lordship.
Affidavit in opposition.
No, Your Lordship, main petition.
Main petition.
Yes, Your Lordship. Your Lord. Yes, in main petition, their petition, Your Lordship. May kindly come to page number 54, annexure 12.
54.
Yes, Your Lordship.
Page 54.
Yes, Your Lordship. This is Your Lordship reply to the, Your Lordship, notice issued by the ESC to the alleged accused, Your Lordship. May I read, Your Lordship? Your Lordship, from sir, I will read, Your Lordship. Sir, in
But
response.
the ESC has come into the picture.
Okay, Your Lordship, may kindly come to 2, column 2, Your Lordship. Point 2.
Clause 2.
Point 2, yes, Your Lordship. In their representation. It's there, Your Lordship, personally. To the extra assistant commissioner.
How the ESC has come into the picture? What's the power of the ESC to issue such notice?
Your Lordship, I will come to that also, Your Lordship. That, sir, I have already paid 7 lakhs.
Yes.
In SBI so and so, check so and so dated, you list mentioned dated 8/6/2018 to so and so, in spite of their asking amount of 6 lakhs through Tabit Tapang Advocate long time, a copy of money receipt and check is enclosed for reference, please, Your Lordship. Here he has enclosed that forced check, Your Lordship. And now, so far as Your Lordship has pointed out, that whether EAC has the jurisdiction or not, Your Lordship. I will come to that, Your Lordship. Now, Your Lordship, my brother has submitted the AFR is repealed. Your Lordship, may kindly see the gazetted
There is no
notification.
such order, AFR is repealed. There is no such order. Only on the basis of the notification he has submitted. it.
Yes, Your Lordship. So it's still prevailing, and the Gaon Bura Bill Authority and EAC, they are exercising their power, Your Lordship. Here, Your Lordship, the issue.
Passing of this notification also?
Yes, Your Lordship. Your Lordship, may kindly see this notification, Your Lordship. This is the notification, Your Lordship, by the gazetted notification of Arunachal Pradesh, Your Lordship. Here, Your Lordship, if Your Lordship, it was repealed, then how the state government will issue this gazetted notification for amendment of AFR, Your Lordship? Your Lordship may find it in short title 1, Your Lordship.
1.
Yes, Your Lordship. This act may be called as Assam Frontier Administration of Justice Regulation Amendment Act 2023. If it is not in existence, then how amendment will come? It's, Your Lordship, it's point 3, Your Lordship. It shall be deemed to have come into force with effect from 20 February 1987, Your Lordship.
Where is it?
Your Lordship, in short title 1,
Para?
3, column 3, Your Lordship. It shall be deemed to have come in
Amendment of section 2.
1, Your Lordship. Section 1. Yes, Your Lordship.
Para 2.
Para 2 and 3, Your Lordship. It shall extend to whole of state of Arunachal Pradesh. 3. It shall be deemed to have come into force from with effect from 20 February 1987. Certain amendments was done, Your Lordship, insertion of certain, Your Lordship, headings, Your Lordship, and the bill, and there are some addition of, Your Lordship, certain words in the AFR, Your Lordship. If, Your Lordship, it was not in existence, how, Your Lordship, this amendment will be issued by the state government, Your Lordship? And, Your Lordship, the second, Your Lordship, my humble submission to my understanding, Your Lordship, Your Lordship is well aware of the,
It's contradictory.
yes, Your Lordship is well aware of the maxim, Nalam Tempas of Locus Occurrit Regi, Your Lordship. Crime never dies, Your Lordship. Here, Your Lordship, in 195, here, Your Lordship, EAC, seeing the order of the EAC, it can be presumed that EAC has acted under AFR. Now, Your Lordship, may kindly see the provision under section 195 of the CRPC. It doesn't legislature doesn't use the word competent court. The legislature has used word any court. It doesn't speak about whether the court which has the jurisdiction, only that court can initiate the or file a complaint. It says any court, meaning thereby, if court acted on behalf of the act, if it's acted as a court, and during the pendency, if somebody forged the document, then, Your Lordship, the offense is attracted. Here, Your Lordship may kindly come to the provision of 195. Your Lordship has gone through. I will read, Your Lordship, just on interpretation of the legislature, Your Lordship. Legislature intention, Your Lordship, 195. 2, Roman 2B2, Roman 2. May I read? Of any offense described in section 463 or punishable under section 471, section 475 or section 476 of the said code, when such offense is alleged to have been committed in respect of document produced or given in a proceeding of in any court. Now, Your Lordship, I'll pause for a moment. The legislature has used word, although it's not relevant, however, Your Lordship, the legislature has inserted word any court. The legislature has not inserted the word competent court. Legislature has not intended that the forgery should be done before the court which has the jurisdiction to take up the matter. It clearly it means because the provision clearly says the authority should be act as a court, whether it has a jurisdiction or not. Supposedly, your lordship, if somebody file an anticipatory bail for the juvenile, your lordship, which has been settled by this court, which is not maintainable, and in the anticipatory bail, they make a forced affidavit, your lordship. So since it is not been maintainable, whether, your lordship, that offense committed by the person will be diluted? No. The offense will remain there, your lordship. Whether the court, it is maintainable or not, whether the court has a jurisdiction or not, that is other aspect. But the offense at that point of time you have committed, that will remain there, your lordship. And here, your lordship, why I am saying the 195, I'm not stretching on 195. Why? Because, your lordship, that was manufactured and then produced, your lordship. And your lordship, again, your lordship, I will take your lordship to the affidavit in opposition they have filed. Why, your lordship, I am coming on that, your lordship, even this, before this court, they have filed the fourth document, your lordship. Even before this court, before any order passed by the executive magistrate, before filing the reply, they have forced the document, and the same has been filed before this honorable court. Your lordship may kindly, in their affidavit in opposition. Yes, your lordship. Affidavit in opposition in page number, your lordship, 12, annexure 1. This is the writ petition which was later on withdrawn. Here, in this writ petition, there was no interim order, your lordship. Annexure 1, page number 12.
Page 12.
Yes, your lordship. Your lordship, I will take your lordship directly to the para 10, your lordship. Para 10, yes, lordship. Where they have annexed the check, the petitioner begged to state that on receiving the legal notice dated so and so, the petitioner had sent one advocate T. Tapak with a check number so and so, the same check, of amount of rupees 7 lakh in the name of Sri Otok Tamut Talom, wife of private respondent. At this stage, the petitioner categorically begged to state that the private respondent has refused to accept the said check, stating that until full payment along with the interest amount to 18 lakhs is not paid, the private respondent will not accept the said check, so and so. Your lordship may now come to the annexure of this writ petition.
Annexure?
3, your lordship, page number 31. On oath, your lordship, this where it was filed. Here, your lordship will find here also the annexure 3 series, 31 page number. Here also, your lordship will find on the right side top.
Yes, that is that he has shown, no?
Yes.
16 and 18.
18. This was, your lordship, forced. Actually, by the time when the check was issued, it was 2016. And he forged it, your lordship. And your lordship, I will come to the material collected by the investigation authority also, where he has admitted that he has corrected the date, your lordship. Now, your lordship, I will now, so far as your lordship 463 is concerned, it doesn't say that to attract section 463, the document must be an original document. No, it says even making a document with an intent, with an intention, the intention must be there. As I have read out, your lordship, the representation reply they have submitted, they have said that they have already paid the amount, so as to cheat the concerned authority, so that the concerned authority may not pass any adverse order against him, your lordship. And so far as, your lordship, I have already produced this, your lordship, AFR, it clearly says it was in force. Even it was not in force, the allegation is forging the document outside the court, for which, your lordship, court has a jurisdiction to take cognizance, and the investigation authority can also investigate the matter. And now, your lordship, although the learned court below has not framed charge under section 420, but, your lordship, section 216 is always there. If during the proceeding, pendency, during the trial,
Challenge this coming of charge.
your lordship, I have not said, but, your lordship, during the pendency, if any material comes up, then the learned court below is not unit of power to add new sections under 216. Your Lordship, now Your Lordship, how 420 is also, Your Lordship,
Charge sheet has been submitted for 470 and.
420, yes, Your Lordship.
470
Yes, Your Lordship. Yes, sir. Now, Your Lordship, so far as my brother has submitted if the foundation of the case goes, then even the criminal proceeding goes. In my humble understanding, Your Lordship, it will be depend on fact and circumstances of the case. For say, Your Lordship, if there is a dispute between two parties, when one of the parties has a civil suit is pending for a disputed land, for example, Your Lordship, and at the same time, the party has filed an FIR against the other party for trespass as well as for assault. Later on, if civil court pass an order in favor of the party that the land belong to that party, then no doubt the section of trespass will go. But the assault he has committed at that point of time, that will remain there. Because, Your Lordship, crime never dies, and it has to be looked into with the fact and circumstances of the case. And so far as, Your Lordship, allegation of cheating is concerned, Your Lordship may kindly come to, we have not, Your Lordship, since this is a 482 application, Your Lordship, we have to directly actually come to the FIR first, Your Lordship. Because, Your Lordship, the court has to see whether allegation made in the FIR does constitute any offense or not. And basing on that, the investigation has been carried out, whether the investigation authority has collected sufficient material, prima facie material, on the basis of which the accused may be warranted for the trial or not. So now, Your Lordship,
Received 2 lakhs, no, on behalf of.
no, Your Lordship, till that no amount has been paid.
Money receipt is there.
Not money receipt, Your Lordship, that is receipt pertains to check, that he has, for record, he has received the check. Your Lordship, may kindly come to that portion, Your Lordship.
Behalf of so and so.
Okay. Your Lordship, we'll directly go to the FIR, Your Lordship. And Your Lordship, the other aspect regarding civil dispute, Your Lordship, before the Kaba and all, Your Lordship, that all these are disputed fact which has to be considered during the trial, Your Lordship. At this stage, in my humble understanding, Your Lordship, time and again the Honorable Supreme Court has emphasized that the Honorable High Court, while exercising power under 482 or 397 for quashing of criminal proceeding, the law doesn't permit the Honorable High Court to hold a mini trial, Your Lordship. And Your Lordship, the learned and the Honorable Court cannot embark into the material and evidence meticulously, Your Lordship. The Honorable High Court has a limited jurisdiction to see whether allegation disclose the commission of any offense. It says commission of any offense or material collected by the investigation authority disclose any prima facie material so that the person can be prosecuted or face the trial. Now, Your Lordship, may kindly come to the FIR. Let's see the FIR first, Your Lordship. Your Lordship, may kindly come to page 59, Your Lordship.
Page?
59 of their petition. 59, the FIR.
Page 59.
Yes, Your Lordship. Let us see the allegation therein and the material collected so far by the investigation authority, which culminate into charge sheet, Your Lordship. Yes, Your Lordship. To the officer in charge, Police Station Naharlagun, Arunachal Pradesh, FIR against Sri so and so, son of so and so, for cheating and forgery. Sir, with due respect, I am to state that Sri Obuk Mize, on pretext of some urgency to engage excavator for art cutting at Papunala, has fraudulently induced me to deliver him a sum of rupees 5 lakhs only on return basis with an interest for the period of 3 months. However, even after 3 months, when he failed to return the amount, I and my husband repeatedly request him to repay the amount with the interest as promised. On 14/6/2018, he sent a check bearing 620361 of the SBI, Itanagar branch, for an amount of rupees so and so, only through one Sri so and so. However, fraudulently, he again returned two debts in the same check. That is 8/6/2016, shown as check date on the top of the right, and 8/6 2018 shown in the signature column. Thus, I and my husband could understand his ill intention to cheat me from the very inception of receiving money from me on the pretext of loan, as the said check was issued invalid. It was invalid, your lordship. The check validity is for only 3 months. Since the valid,
Whether you have crossed before this, that person that kindly change the date and issue a fresh check.
that is not there in the record. That will reply by the counsel appearing for the other side, your lordship. But till that, your lordship, there is no any material to show that they have a bona fide intention to repay the amount. Your lordship, kindly see, your lordship, a person taken a loan and for the period of 3 months. Now they are disputing the interest amount. No, that can be disputed before the civil court, no doubt. But your lordship, the person concerned is issuing a check. Pres-
Slip of pen.
Your lordship that will be clarified from his statement, your lordship. His statement, okay, your lordship may kindly come to the 161 statement, your lordship, of the accused. This is the part of the record, page number 101. Whether there is a material 101, your lordship, I will directly come to the questioner, your lordship.
Yes, please. Yes,
A questioner, your lordship, for 101. Para 4, your lordship. In your reply to show cause notice dated so and so, submitted to ESC Narlagan, you have annexed the copy of the same check bearing serial number 62036, which you have given to so and so, and in copy of the check submitted to ESC Narlagan, you have mentioned its issue date as 18/6/2018. While in the original check, it is 18/6/2016, and also in your written reply at para number 2, you have mentioned in the check date as 2018. Why you have done?
In the FIR,
No, your lordship, the statement, 161 statement,
161,
statement of the accused,
page number?
101. Part of the record. Third line. Fourth line, your lordship. Question. Fourth.
100.
101, your lordship. I will only read the operating portion. Fourth, your lordship.
In
Fourth.
response to show cause.
Yes, yes, your lordship.
Yes, yes.
In your reply to show cause notice dated so and so, submitted to ESC Narlagan, you have annexed the copy of same check bearing serial number so and so, which you have given to so and so, and in the copy of the check submitted to ESC Narlagan, you have mentioned its issue date as so and so, while in original check it is so and so. Also in your written reply at the para number 2, you have mentioned the issue date at so and so. Why you have done this? At the time of issuing the check so and so, I have kept a scan or photocopy of the check with me, and after observing the date of issue as 18/6/2016, I have corrected and made it 18/6/2018. In all the correspondence related to the said case, I have annexed the copy of check with corrected date, your lordship. Your lordship, he is not correcting it in the main check, and when the document is produced before the court, he is correcting it, your lordship. What is this, your lordship? He should have approached the court, he ought to have approached the court with a clean hand. And that too, your lordship, after expiry of so many years, your lordship. If he supposedly, your lordship, at the time when he has issued it, and your lordship, that check was returned back to the mediator, that is Advocate Tabitha Pak, your lordship has seen the receipt. That receipt, from that receipt, it can be clearly, your lordship, presumed that the check has given back to the mediator, and it was in the possession of the mediator. In the later stage, your lordship, the same was collected by your lordship, the present respondent, your lordship. But the same was,
He issued another check.
no, your lordship. Till that, no check, nothing, your lordship. That is the issue here.
Then how stated I have corrected and made it at 18/6/18?
Yes, your lordship. He has corrected in the copy, your lordship, which he has retained. The original check was with the respondent, your lordship,
Yes.
the victim.
Check is-
So it clearly shows his intention, which required, your lordship, trial, your lordship. Because the prima facie case is made out, your lordship. Whether the intention, your lordship, at this stage under 482, the intention of a person cannot be, your lordship, established at this stage, for which, your lordship, trial has to be conducted, your lordship. And your lordship, the Raned court below has correctly, your lordship, taken cognizance, because for taking cognizance under section 463, there is no any bar as such for the document which has been manipulated prior to the production of the same before the court. If it was produced and then it was corrected or forced, then question of 195 come into play, your lordship. Here is a clear case. He has, as my learned brother has fairly submitted, that was corrected, according to him corrected, but according to the prosecution side, that has been manipulated with an intention to cheat or intent to get some benefit out of it, your lordship. So prima facie case is clearly made out. And your lordship, so far as your lordship, regarding the your lordship, AFR also, your lordship, these are now disputed fact now, which required to be adjudicated by the learned court below, whether at that point of time, all this aspect has to be considered, because my learned brother has submitted by relying on the notification that it is not prevailing. It is impliedly, your lordship, repealed, but it is still prevailing. And on 2023, if notification has been notification for amendment.
I'll clarify that point in my rebuttal, my lord. The amendment, I'll clarify this point. My lord, my friend has not, probably have not read the judgment of this court. It is impliedly repealed to the extent of the village authorities adjudicating civil and criminal disputes. To that extent, it is repealed. There are other provisions in the AFR, like police functions, police officers.
That is continuing.
Yes.
Your lordship may kindly come to then in that case to the notification, because it was not repealed, because village council is again here notified by the state government. Your lordship may kindly come to the this amendment of the gazetted notification of AFR. Your lordship may find in the column 4.
Column 4, yes. Amendment of section 4.
After clause E, the following clause shall be added, namely, the village authority means member of the traditional village council or inter-village territorial council or apex court by whatever name called, including head Gaon Bura, head Gaon Buri, Gaon Bura, Gaon Buri, and traditional village head. Where, your lordship? It's still there.
Regulation 40, because regulation 40 speaks about the authority to adjudicate criminal and civil matters by the village authority and the deputy commissioner.
That is deleted. No?
Yes, yes.
No, your lordship, the village council, they are still exercising the power, your lordship.
Erroneous.
See.
Your lordship, your lordship, even if assuming the village authority don't have the power, as I've already submitted, the word used in the 195 provision, the legislature has not used the word competent court. If it is produced before the competent court or not, meaning thereby, when even if the court, without having the jurisdiction, it exercising its power as a court.
Yes, please.
And now your lordship may come to the 482, your lordship. What aspects are to be considered, your lordship? Yes, your lordship. Because your lordship, my learned brother has submitted on the many factual aspects, your lordship, which are disputed fact, which cannot be adjudicated while considering the 482 application, because the court cannot hold mini trial, your lordship. Your lordship may kindly come to para 17. 2023. 2023 SCC online, SC 765.
Please.
Para 17, your lordship.
Para 17.
Yes, your lordship. This is a case where the charge have been framed, same situation, and accused are awaiting trial. Having regard to the totality of the fact and circumstances noticed above, we are of the considered opinion that the investigation and the follow-up steps are not so patently and unobstructively defective or error, except to the extent we propose to mention before concluding our judgment, that allowing the trial to progress might have caused a miscarriage of justice. This is also not an appropriate stage to delve deep into the records. It is no part of the business of any of the court to ascertain what the outcome of the trial could be, conviction or acquittal of the accused. The small window that the law through judicial precedent provides is to look at the allegation in the FIR and the material collected in course of investigation without a rebuttal thereof by the accused, and to form an opinion upon consideration thereof that an offense is indeed not disclosed from it. Unless the prosecution is shown to be illegitimate so as to result in abuse of the process of law, it would not be proper to curtail it. The principle to be borne in mind with regard to quashing of a charge proceeding either in exercise of jurisdiction under section 397 CRPC or section 482 CRPC or together as case may be, has engaged in attention to this court many a times. Reference to each and every precedent is unnecessary. However, we may profitably refer to only one decision of this court where upon a survey of almost all the precedent on the point, the principle has been summarized by this court is currently in Amit Kapoor versus Ramesh Chandra. This court laid down the following guideline principle. 27.1. Though there are no limit of the power of the court under section 482 of the code, but the more the power, the more due care and caution is to be exercised in invoking this power. The power of quashing criminal proceeding, particularly the charge frame in term of section 228 of the code, should be exercised very sparingly and with circumspection, and that too in rarest of rare cases. 27.2. The court should apply the test as to whether the uncontroverted allegation is made from the record of the case and the documents submitted there with prima facie establish the offense or not. If the allegations are so patently absurd and inherently improbable that no prudent person can ever reach such a conclusion, and where the basic ingredient of the criminal offense are not satisfied, then the court may interfere. 27.3. The High Court should not unduly interfere. No meticulous examination of the evidence is needed for consideration. Whether the case would end in conviction or not at the stage of framing of charge or quashing of charge. Here says not meticulously, court should look into. 27.4, where the exercise of such power is absolutely essential to prevent patent miscarriage of justice and for correcting some grave error that might be committed by the subordinate court. Even in such case, the High Court should be allowed to interfere at the threshold to throttle the prosecution in exercise of its inherent power. 27.5, where there is an express legal bar enacted in any of the provision of the code or any specific law in force to the very initiation or institution and continuation of such criminal proceeding, such a bar is intended to provide specific protection to the accused. Here also this bar will not operate because 195 is not attracted, Your Lordship. 27.6, the court has duty to balance the freedom of a person and the right of the complainant or prosecution to investigate and prosecute the offender. The process of court cannot be permitted to be used for an oblique ultimate ulterior purpose. Where the allegation made and as they appeared from the record and the document annexed therewith to predominantly give rise and constitute a civil wrong with no element of criminality and does not satisfy the basic ingredient of criminal offense, the court may be justified in quashing the charge. Even in such case, court would not embark into the critical analysis of the evidence. 27.9. Another very significant caution that the court have to observe is that it cannot examine the facts, evidence, and material on record to determine whether there is a sufficient material on the basis of which the case would end in conviction. The court is concerned primarily with the allegation taken as a whole, whether they will constitute an offense, and if so, it is abuse of the process of the court leading to injustice. It is neither necessary nor is the court called upon to hold a full-fledged inquiry or to appreciate evidence collected by the investigation agency to find out whether it is a case of acquittal or conviction. 27.11, where allegation give rise to civil claim and also amount to an offense, merely because a civil claim is maintainable does not mean that criminal complaint cannot be maintained. 27.12, in exercise of its jurisdiction under 228 and or under section 482, the court cannot take into consider external materials given by an accused for reaching the conclusion that no offense was disclosed or that there was possibility of his acquittal. The court has to consider the record and document annexed therewith with prosecution. Quashing of a charge is an exception to the rule of continuous prosecution. Where the offense is even broadly satisfied, the court should be more inclined to permit continuation of prosecution rather than its quashing at the initial stage. The court is not expected to marshal the record with a view to decide admissibility and reliability of the document or record, but is an opinion formed prima facie. 27.14, where the charge sheet report under section 173(2) of the code suffer from fundamental legal defects, the court may be well within its jurisdiction to frame a charge. Even if it is, Your Lordship, defective, the court can frame charge. 27.15, coupled with any of all of the above, where the court find that it would amount to abuse of process of the court or that the interest of justice favor, otherwise it may quash the charge, the power is to be exercised ex debito justitiae, that is to do real and substantial justice for administration of which alone the court exists. 27.16. These are the principles which individually and preferably cumulatively be taken into consideration and as precept to exercise of extraordinary and wide plenitude and jurisdiction under section 482 of the code by the High Court, where the factual foundation for an offense has been laid down, the court should reluctant and should not hasten to quash the proceeding, even the premises that one or two ingredients have not been stated or do not appear to be satisfied if there is substantial compliance with the requirement of the offense. At this stage, Your Lordship, meaning thereby the court should presume the material collected by the investigation or the prosecution is true. And the basing of that, the prima facie case is made out. The court normally may not interfere, Your Lordship. That is the clear guideline, Your Lordship. And the material whichever has been relied by a learned court, whether that is the part of the record in the LCR or not, that has to be looked into. Because at this stage, court. Yes, Your Lordship. That all that aspect, the disputed fact, can be raised during the trial also, Your Lordship. The only aspect which has to be considered at this stage, whether there is a sufficient prima facie material which constitute the offense, alleged offense against the accused is there or not. If not there, then court is well within its jurisdiction to quash the matter. But so far as Your Lordship, I have already, Your Lordship, pointed out this, so far as 195 is concerned, it will operate only when the document is in the custody legis, meaning thereby it is in the court. Then 195 will play. But this is a case where document has been forced outside the court. And for that, full trial has to be commenced because intention cannot be called out at this moment. Intention, it has to be done during the trial, whether the person has a criminal intention or not, with an intention to force, with an intention to cause loss or damage to the present party, Your Lordship.
Yes, please. Private person, no? Respondent 2.
Respondent number 2. My lord, in this regard, firstly, my lord, the charge sheet. It was submitted under section 191, 420, 468, and 471. During consideration of charges, the other sections were dropped, but section 193 and 463 have been 193. They have been accepted. Now, the reason, my lord, why we have repeatedly reiterated in our opposition that ingredients exist for submission, framing of charges under section 420 and 468 is, my lord, because of section 216 of CRPC. As my lord knows, before the pronouncement of judgment, the Honorable Court has the power to alter and add the charges, if they be so. Now, Lordship, 420. Why we were going after 420 was because, my lord, in the facts of the case, firstly, undoubtedly it is a dispute that arose because of some money transaction that arose. For attracting 420, the requisite is that there should be intention from the inception. Now, Lordship, at this moment, it is not in our control and it is not even under their control. I believe that they show that intention can be shown, that they did. I cannot show at right this moment that they had a bad intention or ill intention to not honor their commitment. Neither they can 100% show that they had the intention to commit or that honor the check. My lord, because intention has to be derived from conduct, Lordship. Now, Lordship, after the check was issued, the invalid check, they have not, it would have been very easy, supposing if they had issued a fresh check with a fresh date, this controversy would not have arisen. It was not there. Now, Lordship, when this check, it was returned to the advocate who had approached us with the check, it was informed to him, it was within his knowledge. What he did, my lord, was he did not issue a new check. What he did was instead he had a photocopy. So now, my lord, nothing prevented him from using that photocopy, wherein 2006, 16 and 18 are there. It is undisputed, it was there. Nothing prevented him from using that photocopy, from asserting his claim that an attempt was made to pay off the debt. But what he does was, he changes the dates. Now, he not only changes the date, he uses the changed photocopies to submit that he has paid off his liability. That is his intention, what we are deriving that he had ill intention. My lord. Now, my lord, regarding this, he had full knowledge that the original check was not in my possession. The original check was in possession of advocate for nearly 6 months. Now, supposing, my lord, if during those months, if he had obtained the check and he had changed the dates from 18, then he would have been able to substantiate his claim. But before he could do something like that, the original check was taken into my possession, and then a case was filed. Now the law has been very laid down by both the parties, my lord. That
Original is with you.
original we had afterwards, my lord. Afterwards, when it was given to me, I had returned it, and but after some months, I had taken the check from the advocate. That is on
With
record.
you.
It is what with me. Now, my lord, they in their petition they have taken a stand that it was a bona fide mistake. My lord. Now, interestingly, my lord, the bona fide mistake is an afterthought that has not arose before this criminal case was filed, my lord. In our annexure 1, my lord, that is the writ petition that has been already showed to my lord that in this case also, my lord, they have used the check wherein both the dates are 2018 and 18. Now, my lord, nothing has prevented them from here also to show that the bona fide, my lord, how can bona fide of a person can be determined? It will be determined by his actions. Now he is saying something, he is doing something. If he had used the old check of 2016, it was all right, bona fide. Now at this moment, my lord, by his conduct, by how he's manipulating the records for his own advantage, that is what we are seeking, that we are praying that that may be determined during trial. Because that bona fide intention of theirs, which was not apparent, because in the legal notice, my lord, it was very easy to write. I had made a mistake. There are 2 dates. I will issue a fresh check. No. He has categorically asserted that I have issued the check, you use it. Now he has issued an invalid check and he's asking me to use it. I've returned it. He's not willing to take it back. That was not. Then he files a writ petition before this honorable court. There also, now, he does not make any claims regarding that there was an oversight. Some dates were like that. No. He is again making categorical statement and he even has the audacity to annex the altered photocopy before this honorable court. He has not used the previous this check, my lord. Now they are saying that his bona fide may be seen. His bona fide will only be seen in my humble understanding through his conduct. That we so, my lord, that if his conduct is seen, my lord, he only began using the defense of it being a bona fide mistake after the FIR was filed, my lord. There is no record, at least we don't have any record, lordship, wherein they have taken the plea of bona fide mistake before the FIR was lodged. Now, after the FIR was lodged, they suddenly started saying that, oh, okay, there are 2 dates, there was a bona fide mistake. It was only after the FIR that was there, my lord. Because as, my lord, even in the reply before the ESC, I believe that is not there. They have not made any mention regarding the 2 days, lordship. They are only doing this after filing of the FIR. Now that be so, my lord, then it is my humble submission, my lord, as they have already cleared up the law that 195 cannot be attracted because 2018, my lord, even if I've understood correctly, the petitioner was submitting that the custody of the check began in the year 2019. The writ petition was filed in October of 2008. That was before the ESC proceedings initiated, the SOCOS was given. If that be so, my lord, that the petitioner has been using the alleged this forged document way before it was in the custody of the honorable court. Therefore, my lord, if they are saying that their intention should be seen under 420, it is prayed that that may be seen in trial, my lord. And as we are saying, my lord, I may reiterate, my lord, that there are sufficient material, in our understanding, there are sufficient material to attract 420 because he did not have a bona fide intention to honor his commitment to repay the amount that was taken to me. And that bona fide intention or any intention that he may have can only be determined by the trial court, my lord. With that, I will conclude.
My lord, only a quick rebuttal to the specific points, my lord. My lord, the public prosecutor has argued more than the private respondent, my lord. Now, my lord, because, my lord, I was under impression that the public prosecutor will just lay down the law and not dwell much on the facts. But the manner the
Because it's a
public,
482 petition, not much more than that.
my lord,
That's why the public prosecutor has the right to.
my lord, in a 482 petition, the learned public prosecutor is making submissions. My lord, here, my lord, will kindly appreciate. What are my ground of challenge, my lord? My ground of challenge, I am not coming up with any evidence to show, to counter facts. My ground of challenge is at jurisdiction level. My ground of challenge is that there is a statute which gives a right to a person, certain protections are there, that has not been followed. You are dragging a government servant in a criminal court just to wreak vengeance. From 5 lakhs, you ultimately, my lord, 5 lakhs, shoot it up to 20 lakhs, you want that, you have dragged me. My lord, the submissions which is relying on a recent judgment 2020, that is on a completely different basis. That is what, suppose, my lord will just bear with me, because, my lord, I need to clarify certain fundamental, my lord, flaws in the submissions, my lord. My lord will see what happened. Suppose there is a case that X have cheated Y or X have committed some, maybe murder, rape, dacoity, whatever may be, some allegations under this. Then I come up with some evidence in a 482 petition. That no, at that point I was there, plea of alibi, at that point I was there. Correct. In those circumstances under 482, court cannot go into the whether he will be acquitted based on this evidence or he will be convicted based on this evidence. 482, he cannot go. I am the last person to make that submission. What I am saying here, the ground of challenge is what? That the foundation of the case is flawed. Therefore, I had to indicate to those facts, just to impress on this lordship, that this criminal case has emanated from a proceeding which has got no legal sanctity. Coupled with the fact of 195, I am not coming up with any factual defense. This is one. The public prosecutor has, with my lord, is time and again asserting that the check was, that the photocopy of the check was for outside the courtroom. My lord, on the basis of what he is making this submission?
Your Lordship, if there is a specific allegation against me, Your Lordship, I will humbly submit, Your Lordship, whatever I have submitted on basing on the record. If their record is incorrect, that I don't know, Your Lordship. But if their record clearly says, only 161 statement Your Lordship has gone through, where he himself has said that before filing of the same, he has corrected. Because my brother is assailing me, Your Lordship.
No. Now, my lord, my lord, only on law point, I'll just rebut on law points, my lord, because the entire moment, my lord, the entire case is being looked from a different perspective by the learned public prosecutor. Here is a jurisdictional issue, number one. Number two, my lord. Now, my lord, this is another submission, my lord, in my limited understanding, I could not understand. He is saying the legislature used the word court, it does not mean competent court. So, after the court hours, me and my junior go and sit there and claim ourselves to be a division bench of the High Court, and somebody makes some appeal, I will say, no, this is may not be court, it is competent. These are, my lord, court is presumed to be competent court. Otherwise, my lord, legislature court means competent court. Court will not mean court, incompetent courts, my lord. So therefore, my lord, this, now, my lord, just one, and this 161 statement where I confess, and that is relied on as a material, my lord, section 25 of the Evidence Act still exists, my lord, still exists in the statute books. Is it not directly hit by section 25? Can, my lord, if that be so, what prevented the state machinery from getting my statement recorded under 160? You are attributing criminality on me based on a 161 statement. And you are saying that this is
argued all this.
no, my lord, just my lord, what
Repeat, no?
certified, my lord.
Don't.
No, I'm not repeating, my lord. I'm absolutely not repeating. I'm just countering, my lord. I'll kindly appreciate, because these things need. Now, my lord, this amendment I have already submitted. This amendment does not relate to rule
Section 14.
42. Therefore, this court. Court does not mean criminal court, my lord. Court does not mean competent court, as he has submitted, my lord. Court always means competent court. I don't think the legislature in its wisdom will
Try
ever
the proceeding.
cheating. Now, my lord, they are harping on cheating and 216. My lord, I do not know why did not they make the same argument before the court below during framing of charges, because they are saying on the basis of this material, on the basis of their, my lord will kindly see the tricks that has been employed, my lord. They are not saying that material will come and therefore 460. They are saying on oath that sufficient material exists for 420, 471. So this 216 argument, my lord, these are simply tricks to somehow drag him so that he can be compelled to pay such an exorbitant amount. The other thing, the judgment which he has relied on quashing, my lord, that judgment also clearly says at para 27.5, 27.5, that judgment also clearly says, this is not a case that I am trying to project an case of acquittal. Here is a case, I'm not trying to project, here is a case where I'm saying that it lacks basic jurisdiction.
Yes, I can understand.
I am deeply obliged, my lord. These are my rebuttals, my lord.
Very good reported. That is reserved, no?
Okay, Your Lordship. Deeply obliged, Your Lordship.
Yes, anything? Yes, the bell button, no?
May I please, Lordship?
Yes.
Lordship, this is a application under section 438 of CRPC, praying for grant of pre-arrest bail to the alleged accused applicants, Srimati Mini Bui Gyati. Lordship, the allegation against the accused person is that on 19 December 2024, the alleged accused applicant has stolen away a LED TV set from his own house located at 0. Lordship, hearing this case, the fact of the case is that, Lordship, the complainant in this case is the brother-in-law of the applicant. Meaning the complainant is the younger brother of the husband of the accused applicant. Lordship, the accused applicant is a lady and his husband is a retired wing commander of Indian Air Force. Due to the nature of service, they stay outside the state of Arunachal Pradesh. Lordship, the accused applicant has a property at 0 in the Hari village. In the year 2017, the accused applicant has constructed a residential OBT house at the land which was gifted by the father-in-law of the accused applicant. The accused applicant and the complainant, they are having land dispute in that area of land. As such, this FIR has been filed against the accused applicant.
So only the matter is stolen of a
Yes,
LED TV.
LED.
So it is possible for a lady to
Yes.
take up the LED TV
And
from a
more-
house of a person?
Yes.
Yes, please.
Yes, so case diary may be called for you.
Yeah.
Case diary or CD. Your
Case
Lordship.
diary.
Yes, yes. So it is certain, Your Lordship.
Protection may be given.
Yes, Daddy?
Yes, Your Lordship.
But the interim?
Yes.
Interim, Your Lordship, I will leave it to Your Lordship discretion, Your Lordship, so far as interim is concerned.
For 30th, in connection with who is apprehending arrest in connection with 0 PSK number 4923 under section 448, 427, 383, 506 IPC. It is submitted by learned counsel for the petitioner that the allegation against the petitioner is that she entered into the house of the informant, ransacked his house, ransacked his house and damaged his property and stolen away one LED TV from his house. It is also submitted that the petitioner under a land dispute is prevailing between the petitioner and the respondent, informant, and the petitioner and the informant, as a result of which this FIR has been lodged. Nanak and Piti has on the other hand, Nanak and PC. In view of the, but considering the nature of the offense, the benefit of pre-arrest will be extended to the petitioner. On the other hand, Nanak additional ethics submits that the D is required. He may be, his statement, allowed before the, he may appear before the IO for recording her statement, considering the submissions of interim, before any decision is taken on the result of the, his diary, the interim pre-arrest will is granted to the petitioner. You can take this, she is prepared before, 1, 2, 3, yeah, take this, she is prepared before our incorporated the investigation. Next it, call for the case diary. What's it?
17, 15. Your Lordship, let it be on 16, fixed on 16.
15.
16.
16.
Yes,
1, 6.
yes, Your Lordship.
16. 16 is what the diary.
If you oblige. Your Lordship, Your Lordship, direction to appear condition, direction to appear before the IO, Your Lordship.
Yes.
Yes, sir.
But 10 days you have to appear.
7 days. 10 days.
7 days?
10 days, 10 days.
7 days?
10 days.
10 days.
10 days.
Any other issue you have?
If you oblige.
Which one? This one? 21 and 22. But the 21 and 22? Unlisted matter. Only the bill matter I have concerned about the bill matters only. Only the bill matters you have submitted, no? Not the RFM matter I cannot consider.
My lord,
Sorry.
one IA
No. You
already,
have submitted during that period, the first hour, that is a bill matters. That I can understand at least.
actually, Your
So
Honor,
no, I cannot consider this issue, yes.
my lord, if not, then that may be changed.
Yeah, the bill. no
Okay.
problem. There's not so much urgency. Bill matters, it's a matter of very the urgency. Yes, please.
Yes, Lordship, I'm for appellant. sir.
Yeah, for the petitioner,
Yes, yes, sir. I'm for a petitioner.
MSC appeal.
Yes,
Okay,
MSA,
appeal.
appeal, yes. sir. The fix for a hearing, sir.
It is fixed for hearing. Huh?
Yes.
It is fixed for hearing.
May I?
Yes, yes. You're for the appellant.
Yes.
Appellant claimant or insurance?
I'm owner of the
Owner of the.
vehicle.
So,
yes, sir.
So the compensation was awarded in favor of the.
Yeah.
Against the owner.
Against me. yes, sir.
Against the owner.
That's why I'm challenge impugn judgment and award dated 4/6/2022.
Where is
Passed
the
by
memo
the
of appeal?
passed by the learned
Memo of
court.
appeal, where is it?
Lordship, I'm
File
before
is very bad. You didn't get it.
before going through the merit of the case, sir, Lordship.
Also, you have to flag it, no? This is memo of appeal, the judgment. memo. Yes, please.
Before going through the merit of the case, Lordship, I would like to highlight the fact of the case, Lordship, for the better clarity of the dishonorable court. Lordship, this is the case of 2014, Lordship. One FIR was received at the Hailung police station to effect that the deceased late Sange Sringh, who was a deceased person, Lordship, who was the operator of excavator, died while working on a formation cutting road on the Hawaii Manchal Road on a spot when a big boulder rolled down from the hilltop over his body. He was the operator engagement under me, Your Lordship. Because the site was going on the Hawaii, Your Lordship. So during the employment, Your Lordship, the date has occurred, Your Lordship. Then accordingly, the father of the deceased person, Your Lordship, file a MSCT, Your Lordship, by claiming the compensation before the learned court below.
What are the grounds of appeal? You have taken some grounds.
Yes, Lordship. My grounds, I'm coming on point, Your Lordship. I'm highlighting the fact of the case so that the clarity of the court, Lordship. Why I'm challenging this impugned judgment and award was passed by the learned court below, Lordship. Lordship, may I draw the attention of this honorable court? My appeal petition, Lordship, page number 27, Lordship. This is a judgment passed by the learned court below, Lordship.
The vehicle was not duly insured during that period.
Insured, Your Lordship.
Insured.
Yes, that's why I'm challenging, because instead of the liability made upon the respondent number 2, who is the insurance company, Your Lordship, made the liability upon me, Your Lordship, for payment of the compensation amount. That's why I'm challenging the
What is the policy?
policy is page number 54, Annexure 6,
1-5.
54.
5.
Yes, Your. Annexure 6 years. This was duly exhibited as exhibited exhibit 3 in the exhibit 7 years. Exhibit 7 by the learned court below years. Annexure 6 is the insurance copy yourself. May I take this honorable court on the page number 27 of my appeal petition here. Parat Arti years.
Judgment.
Yes, judgment.
Page number?
27.
Huh?
27.
Right.
Paragraph 30 onward years.
30. Yes.
May I have? Now it is noted that in the referred judgment of Meena Varial Supra, Salendar Kumar Barua and others, and Beena Prasad Sonari Supra, there was no contract or premium for coverage owner cum driver, and the insurance coverage was limited to third party. The foundation of fact, the circumstances of the referred judgment are completely different from the case in hand on the following ground as under. Since the learned court below referring the judgment placed by the parties before the court, since observing the page number 28 years. What I'm pointing out here is from the where the learned court below is made the error yourself. Yourself. On the one of column 4 LL under WCA for carriers of more than 6 employees, including drivers, and legal liability to persons employed for operation or maintenance and or loading or unloading except TP and OD premium. Para 32, Joseph. Since the premium silent in the policy for legal liability to driver, I cannot hold the opinion that the insurance company is liable to pay any compensation to the claimant as stated by the OP number 2. That is me. Your Worship. Now the learned court below it has made error to made findings and the forcing the entire materials record available before the court as exhibited by the parties, Your Lordship. Now the insurance policy is 54, Your Lordship, Annexure 6, Your Lordship. 31, paragraph 31 says that however, no premium amount has been entered under the head of liability column for LLWCA carriers of more than 6 employees and legal liabilities to person employed for operation or maintenance and loading and landing, TP and OD.
It's as per policy, it's a commercial vehicle package policy.
Yes, it is a package policy. What I mean to say is it is a package policy. Package policy means it's an exclusive policy, Your Lordship. It also cover the risks of the owner driver also, Your Lordship. Because it's a package policy. Package policy is exclusive policy, liability only policy. In addition to the liability only policy, the package policy it covers the every aspect of risks, Your Lordship. Therefore, what I am trying to point out is learned court below has made a manifest error and overlooked the entire materials record submitted and exhibited before the court below, Your Lordship. And my issues before the dishonorable court that the person died during the employment was not a driver. He was a operator, Lordship.
Operator of the vehicle.
The operator of the vehicle, because whoever operate the like heavy machineries, call as operator, not a driver, Your Lordship. And the learned court below has come up with the one track observation that the liability to the driver is absent. That's why he cannot hold the opinion that the insurance.
Driver, only operator.
Yes, he was operator.
Operator of the vehicle.
Operator of the vehicle, because operate.
He's not the driver.
Yes,
He's the driver.
he was not a driver. He was a operator, Lordship.
What do you mean by operator?
Operator means, Your Lordship, the person who operate the machineries such as forklifts and the excavators and the cranes.
163A petition.
A person
It's
who
166. 163A.
no, Lordship, there is no
Has filed
specific.
The claimant has filed the petition under section 166 or 163A.
File a petition under
Okay, this is good.
one 166 and 163A and 140.
Huh? 166 also 163 also.
Yes, 166, 163A and 140.
No. The LCR. Claim petition, please. Claim petition.
On the 3 sections, yours. My grievances is, Your Lordship, I'm not liable. If any person is liable to pay compensation to the claimant, is insurance company, Your Lordship. Because at the time of incidence of the vehicle, Your Lordship, I was having active premium policy, Lordship, with the insurance company, Lordship. But the same was not considered by the learned court below. Hence, I am praying for the remand back to the yes, remanded back to the case to the learned court below for settlement of the issue. Most particularly the issue number 2.
Claim petition, there is no claim petition.
The issue number 2, as framed by the learned court below, the whether the OP number 1 or 2 is liable to pay the compensation to the claimant or not. Your Lordship.
You have filed a WS before the tribunal.
Yes, I have filed a WS. I have filed a WS saying that I'm not liable, Your Lordship. If any person is liable, then the insurance company is liable. Even in the WFs of the insurance company, Your Lordship, they have solemnly declared that the person.
First, where is the claim petition and the WS? Then I'll hear the argument. What place certificates? Where?
Of the appeal, my lord. They have annexed the claim petition.
LCR.
In
There will-
LCR.
There will be a claim petition or anything else. LCR is not received. LCR not received.
LCR is here.
What is going on with this? I don't understand. The 21/12/22, the case record MSCT case number 0819. That is received file A, B, C, D, A, B, and C in original has been received. Where is it? record first, then we'll pick up the matter of hearing some other day. Anything? Any other?
Lordship, if possible, next week, Your Lordship.
Next week, I don't have. any problem.
Lordship, then a small prayer, Lordship, that since this is a long pending case, my lord.
Not a non-pending case, 22 matter.
Oh no, my lord, for hearing it has been pending for the past nearly 1 year, my lord. So it may be fixed on 12, my lord,
12-2
12 to Monday, it will be Monday, my lord, next week, Monday,
next week.
Monday,
12 to in the Monday.
12 is Monday, my lord.
That's so and so, but that appears that. The test report is not properly arranged. So after the sprint of the proper test report, in MSC test number so and so, this is the matter for hearing on 12.
Highly.
Much, my lord.